everyone, and welcome to Crime in Court. This is the rewatch of the 1993 Menendez brothers trial. Erik and Lyle Menendez on trial for the homicides of their parents, Jose and Kitty, who, as we know now, maltreated them for their whole entire lives. There was a lot of SA going on in that house also, and that began when both of the boys turned 6. And for Lyle, it stopped. For Erik, it continued up until recently, until up until the homicides, basically. I think the most recent was like in the month or two before where there was an encounter. So, anyways, so let's get started. I can't remember. Erik did testify to when the last time was before the homicides, but it doesn't matter because it went on their whole lives. And whether it happened that day or not, they were in fear of their parents. So I put together this little slide for you guys here. It's obviously it says 3 ways to freedom. So now we know, I think it was the last video or the video before, we heard from the LA District Attorney, George Gascon, talk about his recommendation to resentence Erik and Lyle Menendez, which would basically throw it to a judge to decide. So the DA agreed that it's most like agreed that they should be resentenced due to, and we read through all of their, we read through his petition for that because they've always been, stellar inmates. They've created all of these programs to help other inmates, especially inmates who have suffered from CA, SA, things of that nature. Erik, in particular, created like this whole art program. They do murals all over the walls. I think that was Lyle's, but anyways, so there's a bunch of different projects that these two have been a part of, and George Gascon, the DA for LA County, had put that in his present or put that in his petition that will go to Judge Jessic, who I have here number one. Resentencing is going to Judge Jessic. So the DA approves of the resentencing or is recommending it, and then Judge Jessic has to make a determination. Another way, so there's multiple ways that the boys can find their way to freedom. The other way is the habeas corpus petition, which has been in play for a little while now. We'll read through it when we finish up the closing arguments. But the habeas petition is basically either, it's saying we have this new evidence, so either grant us a new trial or vacate the sentence, vacate the conviction altogether because we have all this evidence. Not necessarily altogether, but it should go towards, resentencing anyways. So that's in the habeas corpus petition that is with Mark Garagos, their attorney, is fighting for that. He's also, I mean, he's working on all of these things in all of these different ways to get these boys free because I think they need to come home. These men, they're men now. Stop calling them boys. But look at them. They're so sweet and innocent looking in this, and that's why I chose this picture because I really, really think they look so sweet and innocent, and it breaks my entire soul and being to know what they went through. Anyways, all right, let's move on to number 3, which is clemency from Governor Newsom. So this is a new thing. This is more recent breaking news that DA Gascon also wrote some letters, which we're going to read in a second. He wrote some letters to basically advocate for the boys' clemency from Governor Newsom. So we've got Judge Jessic, who is going to be determining the resentencing phase, if any, December 11th. And then On November 26th, there is a hearing to hear the habeas corpus petition. And at any moment in time, we could get some clemency from Governor Newsom. So all of this is going on right now to free Erik and Lyle. So here are the letters that were written by the DA's office to the Honorable Governor Gavin Newsom, Governor of the State of California. Dear Governor Newsom, I write in strong support of Lyle Menendez's petition for clemency submitted to your office on October 28, 2024. Mr. Menendez is currently 56 years old, serving his 34th year in prison. They're almost at 35, I believe. In prison at the R.J. Donovan Correctional Facility. On August 20th, 1989, at 21 years old, Mr. Lyle Menendez participated with co-defendant and brother Erik Menendez in the homicide of their parents, Kitty and Jose Menendez. As they sat on the family's couch, I disagree with that sentiment. They were standing as the boys testified to. The parents were standing and they weren't in a seated position because that explains some of the wounds. Otherwise, yeah, the standing position makes sense with the wound. It matches up with some of the wounds. So, and then they fell to the couch and more wounds were added on. So I'm sure they also say that that's not correct. All right. So, but this is saying that they were sitting on the family's couch, watching television and eating, which is also not true. Both Lyle Menendez and Erik Menendez fired Mossberg shotguns at their parents, striking them multiple times and taking their lives. Mr. Menendez was sentenced at the age of 26 to life without the possibility of parole, or LWOP, which last time I was like, what the heck is LWOP? But I knew, like, it sounded familiar, but I couldn't think of it. Yeah, life without the possibility of parole is LWOP. At the time of the offense, there were credible allegations that Lyle Menendez was the victim of SA and also physical maltreatment at the hands of their father, Jose Menendez. The Los Angeles County Probation Report prepared in connection to the criminal case documented the ongoing molestation that Lyle Menendez allegedly suffered at the hands of his father until he was 8 years old. During during the during his 34 years of incarceration, Mr. Menendez has worked hard to transform his life. He has participated in rehabilitation, including earning his associate's degree in sociology from Southwestern College. Lyle Menendez graduated from the University of California, Irvine with his Bachelor of Arts degree in sociology. And support for all programs developed, laudatory chronos, and the probation report are attached as exhibits. So just a bunch of exhibits proving that um, he graduated from these courses while incarcerated. In addition to continuing his education, Lyle Menendez has created 4 new programs within the R.J. Donovan prison to assist his fellow inmates. The 4 programs include 1. Green Space, 2. Rehabilitation through Beautification, 3. Adverse Childhood Experience and Rehabilitation, and 4. The Youth Life Without the Possibility of Parole Ally. Additionally, Lyle created and wrote the Wire Bulletin, an inmate advisory bulletin for the purpose of communicating inmate advisory council matters to the inmate population. What a great idea. Current statistics indicate a total of 36% of people serving LWOP sentences in California are currently over 50 years old. These individuals are not eligible for elderly parole or compassionate release. Why not? Yet, oh, I guess because of their sentence, but if there's some other possibility where there's this elderly parole or compassionate release, why wouldn't they be eligible? Yet most people serving as with an LWOP sentence are classified as low risk according to the California State Risk Assessment. Mr. Menendez's CSRA score and classification score are the lowest levels possible for someone serving a sentence of LWOP, meaning they are not violent, they are good, upstanding role models in the um, Department of Corrections. And there's no reason to believe that they wouldn't be, making use of their time and being upstanding citizens if they are freed. Our office has communicated with several family members regarding sentencing in this matter, all family members except for Mr. Milton Anderson, Kitty's brother, support commutation. Mr. Menendez's current age of 56, his 34 years spent in custody, his low CSR score, his low classification scores, and his dedication to rehabilitation make him an exemplary candidate for clemency. It's too early in the morning for me to be doing this. Tired. All right, so should you have any questions, please do not hesitate to call Special Counsel Shaylin Joseph and all that information below. All right, this is the second letter. Basically the same stuff, but this is about Erik. Erik Menendez. I write in Dear Governor Newsom, I write in strong support of Erik Menendez's petition for clemency submitted to your office on October 28th. Mr. Menendez is currently 54 years old and is serving his 34th year in prison at the R.J. Donovan Correctional Facility. On August 20th, he participated with co-defendants in the homicides of their parents. And I'm just going to move on because where are we? So Mr. Menendez was sentenced. I'm trying to just read the stuff that applies to Erik here. Mr. Menendez was sentenced at the age of 23 to life without the possibility of parole. At the time of the offense, there were credible allegations that Erik Menendez was the victim of SA and physical maltreatment at the hands of his father. He suffered at the hands of his father starting at the age of 6 and continuing through his adolescent years up until he was 18, which is how old he was when the crimes occurred. At age 12, it was alleged that Jose Menendez began sodomizing his son Erik Menendez. The SA continued to occur once every few months up until the homicide. During his 34 years of incarceration, Mr. Menendez has worked hard to transform his life. He has participated in rehabilitation, including earning his associate's degree in sociology. In May of 2022, he earned his certificate of proficiency in American Sign Language from Southwestern College. It is reported that Erik Menendez obtained this certification in order to better communicate with the hearing impaired individuals who are participating in the programs that he created. What a great guy. Like, these two are just really upstanding, great people in my mind. I know they did what they did. They did it out of fear. And in my mind, they did it. Like, you don't just up and shoot your parents unless there's a reason. And I believe their reason. In May of 2023, Erik Menendez was accepted to the University of California, Irvine. Again, all the support is attached, or well, we won't see it, but it's attached for Governor Newsom to review. In addition to continuing his education, Erik Menendez has created 5 new programs within the R.J. Donovan prison to assist his fellow inmates. The 4 programs include 1. The Life Care and Hospice Connection Program, 2. The Victim Impact and Victim Empathy for Vulnerable Populations, or VIVE, or Vive, however you want to call it, and 12-step and meditation classes that he also facilitates, insight meditation workshops that he facilitates, and the Starlight Peace Project. His current statistics, he also has a very low score, the lowest levels of anyone possible for serving LWOP. Same spiel here. Basically, we support this. Mr. Milton does not. Kitty's brother, Erik was 54, and all of the reasons above. Please give this candidate some clemency. So with that, so that again, let's backtrack one more time. Let's review. So resentencing by Judge Jessic, December 11th. The habeas corpus petition is going to be heard November 6th, and clemency could be possibly any time from Governor Newsom. So those are three possible ways to freedom. We're not out of the clear yet, but there's ways. There's multiple ways here that the boys have multiple options when up until recently, they didn't even think that they would ever see the light of day outside of prison walls. So at this point in time, we've got some renewed hope. 'Cause it's been a while since they exhausted all of their appeals. So they've been sitting there for a while, thinking that they're never going to get out. So this is the renewed hope. So that's a good thing. All right, so let's move on. I have to have this on point 1 or 1.5 speed. I apologize if it is too fast for you. Whoops. But you are able to, when I'm not live, you're able to go to whoops, let me come back to this screen. On the gear, you can click on the gear and you can choose your playback speed. I'm doing 1.5 because I am really crunched for time. I'm not feeling well this morning. It's been a slow day, so I apologize. Wanted to have this done sooner, but here we are. All right, let's get started.
Morning, ladies and gentlemen. It has been my privilege to represent the people of the state of California in this case. And on behalf of the people, I'd like to thank you for your time and your attention in this lengthy trial. It has finally come to that part of the trial where the decision on the defendant's guilt is entrusted to you. What I intend to do is examine the evidence as presented in this courtroom and break it down into 4 different areas. First, I'll discuss the defendant's attitude and treatment of his parents and the relationship they had with their parents for the year preceding the murders. I won't go back to early childhood. I'll confine my comments to the last year. Secondly, I'll be discussing the evidence establishing the defendant's guilt of first-degree murders and conspiracy to commit murder and the special circumstance allegations of multiple murder in line and weight. As you know, the defendant is charged with murder of his father and his mother in counts 1 and 2, and of conspiracy to commit murder in count 3. Thirdly, I'd like to analyze the defendant's story regarding the events in the week prior to and leading up to the murders and their post-murder activities. And that will be followed by just a brief summation. Because of the length of the trial, I have had to take many notes, and I apologize in advance that I may have to review or turn to my notes during this argument. With regard to the treatment of the defendants, or by the defendants, of their parents for the year prior to the murders, as the crime scene photographs demonstrate that are up on this board, the defendant and his brother viciously and mercilessly attacked their parents on the night of August 20th, 1989. The defense has been no less vicious and merciless to them in this trial. The defense has attempted to place the victims on trial in this case. They have made obscene accusations, misleading claims, and outright lies about their parents, who cannot be here to defend themselves. As most of you...
That's a cop-out excuse to say, well, they can't be here to defend themselves, so you can't take their word for it, the boys. It's like, come on. And we have so many other individuals, family members, friends, tennis coaches who came forward and said that Jose was verbally, emotionally, sometimes physically maltreating the boys just in plain daylight in front of people. And nobody ever did anything. The boys reached out to family members for help and nobody did anything. What the heck do you want them to do? They were pushed into doing this because they were never helped. And that's not their family's fault necessarily, because these things weren't spoken about and everybody feared Jose and what Jose would do to them. So grown adults were afraid of Jose and admitted it on the stand. Yet we're going to sit here and vilify their own children who were maltreated by him their entire lives and say that they're monsters. I can't. Sorry.
You know, it's not easy to be a parent. It is, however, easy to criticize. Now, the defense has tried to make both Mr. and Mrs. Menendez out to be monsters. At the same time, the defense has attempted to portray the defendants as helpless children. You have listened to 5 months of testimony in this case, and I'm not going to review all of the testimony presented. It is clear, however, that the defendant and his brother were adults when they conspired to and then murdered their parents on August 20th, 1989. Thus, as I said, I will concentrate primarily on the relationship between the defendants as adults with their parents, Mr. and Mrs. Menendez, starting with the summer of 1988, in order to give a perspective, a backdrop to the murders. In July of 1988, the defendant, Erik Menendez, committed a grand theft from the home of Mr. and Mrs. John List in the Calabasas area. The defendant took money and jewelry from their safe. Later, in July 1988, the defendant, with the assistance of his brother, Lyle, committed a residential burglary of the home of Mr. and Mrs. Ginsburg in the Calabasas area. The defendant stole a safe, jewelry, a computer, china, silverware, and a Soloflex machine, among other things. Later,
Soloflex machine, nice. Do you guys remember the commercials for those? They always had like this big buff bodybuilder, like Soloflex, like those home workout machines. In case you don't know.
when these crimes were discovered by Mr. and Mrs. Menendez, that their sons were involved, in September of 1988, Mr. Menendez accompanied the defendant and an attorney to the Los Angeles County Sheriff's Department in Malibu. At that time, some of the stolen property was returned and actually turned over to the sheriff. However, according to defense witness Ed Fennell, Mr. Menendez paid $60,000 to $70,000 back to the families, Ginsburg and List families, and that was for the property not returned. Understandably, Mr. Menendez was unhappy with the defendant for doing these crimes. Now, furthermore, the parents reacted to the defendants committing these crimes, and this is their relationship with the defendants, by requiring them to undergo psychotherapy. With the recent move from Calabasas to Beverly Hills, the defendants ended up going to a Beverly Hills psychotherapist, Dr. Oziel. Now, according to Lyle Menendez in the tape session with Dr. Oziel on December 11th, 1989, that came late in the trial, Lyle Menendez states that Dad cried after the Calabasas issue. Now, this man, who the defendants attempt to paint as a monster, Jose Menendez, cried when he learned that his sons were involved in these crimes. The parents sought help for the defendants. They cared about their sons. They might not have been perfect, but they were human beings and they had the right to live. According to defense witness Carlos Baralt, who met Jose Menendez in 1959 and who was the executor of the estate and a very close family relative, he came in and testified for the defense. He testified that Jose was jovial, charming, talented, very intelligent, a great guy to be with. He liked Jose very much. The same Carlos Baralt said that Kitty was charming, fun to be around, active, and energetic. According to Mr. Baralt,
Yeah, a lot of narcissists can be fun to be around when they're the life of the party and the attention's on them. It's when you're not behind closed doors being maltreated by them as your children, as the children of them. But yeah, these people can be very charming and very, mm, they can put on a good facade, I'll say.
again, Jose absolutely loved his sons. His life was devoted to educating them in a fashion he thought was best for them. He put pressure on them to be the best and exerted control over them, but he wanted the best for his sons and devoted his time to his sons. He didn't have hobbies. Every minute he had where he wasn't away from work, he spent watching his sons, taking his sons to tournaments. He spent a lot of time with the sons. They meant a lot to him. However, after the Calabasas thefts and after the defendants were adults, sometime late in 1988, Jose Menendez told Carlos Baralt that he wanted to disinherit the defendants, both Lyle and this defendant. And in June or July of 1989, shortly before the killings, Jose Menendez explained to Carlos Baralt that he was frustrated and disappointed in Lyle and Erik, and again talked to Carlos about disinheriting them. Now, the defendant wants you to view him as a helpless, defenseless child. However, this was a man who was committing crimes which brought anguish and heartache to his father, who caused his father a lot of grief, and his father had a lot of high hopes for both him and his brother. There were problems being caused by the brothers, and the father, I suppose, being at his wit's end, said, I'm going to disinherit you. You understand? Straighten up. Now, in the session of December 11th, 1989, Dr. Oziel states to Erik Menendez, I was there, I remember. I remember when your mom called me and told me that your dad was disinheriting you because he didn't like how you were behaving and that he thought you weren't being respectful enough. And he couldn't tell you because he never talked about feelings. And he wouldn't talk about feelings. And I remember telling you that, and you didn't even look surprised. That must have been what your dad was like then. According to defense witness Pat Anderson, who is the aunt of the defendant screamed shut up to his father in front of a crowd of people in the Kalamazoo tournament in August 1989. The defendant told you that he would never do that to his father, never embarrass his father, yet he did that in front of the whole crowd at Kalamazoo. In fact, Pat Anderson said that 10 other games paused for a moment because of the yelling. Now, according to Brian Anderson, the uncle of the defendant, who was also at the Kalamazoo tournament, who also testified in this case.
And that's the one who doesn't want the boys to get out, by the way.
When Jose tried to talk to the defendant after the defendant lost his match in Kalamazoo, he was rebuffed, and Jose was heard to say, "If I can't communicate with you, there's no sense in talking." Brian Anderson said that both the defendant and his brother would talk back to their mother frequently. Lyle would use profane language to both parents. Carlos Beralt acknowledged that, also testified that Lyle disrespected Kitty and would talk back to her. You even heard the coach, Mark Heffernan, testify that when he was there giving the brothers lessons at the Beverly Hills house, he would hear the mother, Kitty, say to the defendants, "Now you have to do this," and he stated that the brothers would then be mad at the mother. Now, according to the defense witness, Ed Fenno, Lyle would not do what his mother asked him to do, and Lyle basically had a go jump in the lake attitude toward his mother. Now, according to Brian Anderson, defendant Erik Menendez would also use profanity.
Lyle had a go jump in the lake attitude towards his mother because she constantly reminded him that he ruined her life and she wished she never gave birth to him. And she also SA'd him for a few years until Lyle became a teenager and he was like, "I ain't gonna do that anymore." And it stopped. Only because Lyle stopped it.
Toward his mother. Now, these witnesses, both defense and prosecution witnesses, observed the defendants disrespecting their parents in the year before the murders. Yet, this defendant claims that he was afraid of his mother and father. The defendant, who was 6 feet tall, went so far as to claim that his mother was about as tall as Lyle, who is nearly 6 feet tall. Now, the defendant was, I suppose, again attempting to mislead you into believing that she was this huge monster who was to be feared. Now, but 5 foot tall Pat Anderson, the aunt, testified that Kitty was only a bit taller than she. She was not this big monster that this defendant wants you to believe.
You don't have to be big to be a violent human being and physically, verbally, emotionally maltreating them. She could be the tiniest little thing. She could be 4'11" and still be maltreating her children.
Believe she was. Now, according to the defendant's friend Perry Berman, this was a friend that was attempted to be used as an alibi, but who refused to come to the house on the night of August 20th. He was the one that was supposed to meet with the defendants at the Taste of LA in Santa Monica, and he was a very good friend of the defendants. He testified that Mrs. Menendez was a very sweet, caring woman. Well, while Mr. Menendez was a disciplinarian, he was very strict. Ed Fenno also stated that another friend of the defendants, Ed Fenno, was the one that lived in Menendez's house from about.
How come family and friends all said that, that testified for the defense said that Kitty Menendez was never friendly, loving, not with her children anyway. She wasn't a good mother. She wasn't she would attend to them sort of, but most of the time she neglected them and uh yeah, I don't know how they could say she's a good mom. She was never affectionate. No one ever saw her being affectionate with them, not even when they were little. So, and she stopped one of the aunts we learned in what is it, closing arguments, and they went over it that she stopped one of the aunts from going over to, or maybe it was the cousin, to go over and give Lyle a hug when he was crying when he was little. Kitty didn't want her son comforted when he was crying, which makes no sense to me, but that's how they did it in the Menendez house.
About October of '88 until February of '89. Mr. Fenno testified that Mr. Menendez was stern and strict. Now, Mr. Menendez expected the defendants to toe the line. His evidence from these witnesses that in the year preceding the murders, the defendant and his brother were not intimidated children, but rather were arrogant men who demonstrated disdain for their parents. Now, it is not uncommon for adult children who live with their parents to have disagreements with them. But if you can't abide by the rules laid down by your father, then you can just get out of the house. You can hit the road. Now,
except when you are being controlled and manipulated by your father all the time, he might make it impossible for them to leave. He might have threatened them if they left. We don't know. But they could have. They could have threatened more things to come, as Jose was very intimidating and scary.
This the defendant apparently didn't want to do. Now, with this relationship in mind, and not thinking about what the defense wants you to think about is baby pictures, this is what the relationship was like in the year preceding the killings. With that in mind, I'm going to turn to the discussion of the crime itself, discussion of premeditation and deliberation.
I also want to say, sorry to interrupt again, but I also want to say that Lyle Lyle and Eric weren't very self-sufficient when it came to doing, being able to provide for themselves or do things for themselves, especially because Jose and Kitty did everything for them. They did their homework. Eric and Lyle were both getting Eric was expected to come home and get his homework done from Jose. And Lyle was also getting his homework done from Jose. Sometimes he would have to call him and they would sit there and do it. So yeah, this is to say that they could just get up and leave anytime. They weren't raised to be self-sufficient and to even know that they could leave at any time. And I'm sure there was some kind of threat about, well, I'll disinherit you or whatever. You'll never see a penny out of me if you leave this family or tell the family secret, whatever it might be. So just think about that when he says, well, they could just get up and leave anytime. They might not know that they have that option.
And murder. Now, Dr. Oziel testified that on October 31st, 1989, the defendant spoke of seeing a movie on the BBC involving a son murdering his father. As Erik Menendez described it, Lyle came in during the movie. He didn't see the entire movie. And that after this movie, the defendant and his brother Lyle discussed how their father was similar to the father killed in the movie, and that the defendant and Lyle then began to discuss killing their own father. Dr. Oziel testified that the movie was shown a few weeks before the defendants killed their parents. We know through the stipulation that on July 30th and 31st, actually 3 weeks before the murders, NBC aired the Billionaire Boys Club 2-part movie. It aired nationwide, including in Beverly Hills and in Tampa, Florida, the place where the defendant, Erik Menendez, testified he and his brother were on July 31st, 1989. Now, this movie included the killing of the father of one of the young men associated with the Billionaire Boys Club. When I asked the defendant in cross-examination about the BBC movie, the defendant suggested that Dr. Oziel must have meant the British Broadcasting Company. However, I confronted him with the fact that BBC also stands for the Billionaire Boys Club. It was not until the defendant was confronted with a transcript of the taped conversation that this defendant had with Craig Signorelli on November 29th, 1989, that the defendant then he was actually forced to admit that he knows that BBC stands for the Billionaire Boys Club.
I think he's misrepresenting what actually took place. Was Erik said he didn't know what he meant BBC to be standing for when Dr. Oziel first brought it up, and he originally thought it was the British Broadcasting Channel.
And was further forced to admit that in that conversation, November 29th, 1989, that the defendant spoke about starting a business corporation like the BBC, like the Billionaire Boys Club, in which he and his friends would make $1 to $2 million and they would get a Rolex watch. Now, the defendant has throughout this trial attempted to lie and to mislead you by suggesting that Dr. Oziel must have been a movie on the British Broadcasting Company, when he knew full well that the BBC stood for the Billionaire Boys Club. Now, it's understandable why he didn't want you to associate the two, because that would not have looked good for the defendant. You will also recall, I believe, that he first tried to deny that he wanted to be an actor. But as the evidence developed, and as you heard on the December 11th, 1989 tape, he indeed wanted to be an actor. But he couldn't admit that because that would look bad for him too. So unless he's pressed, unless there's something right on tape, he's going to deny it, he's going to lie about it. And even if it's on tape, he's going to come up with another story. Now, as 21 and 18-year-old adults, the defendants discussed getting rid of their own father to be rid of his control and domination and to be rid of the person who prevented them from doing what they wanted to do. They needed to get their father out of their lives. They felt that if their father continued to live, they would have no freedom in their own lives. That's what they told Dr. Oziel. Now, Dr. Oziel testified that the defendants said that they decided to kill their father, but the decision to kill their mother was harder for them to decide. As you heard the language of Lyle Menendez, it was a harder issue. A harder issue. Killing your mother is an issue. The December 11th, 1989 tape confirms and supports Dr. Oziel's testimony here. Now, Dr. Oziel was attacked viciously in this trial. He was attacked. People were brought in to say bad things about him. But in the final analysis, the defendants admitted most of what he testified to. And in fact, the December 11th, 1989 tape also confirms what Dr. Oziel testified to. Referring to the December 11th tape then, this is the brothers' voices, their own voices. When you have information, you have a witness that gives information against the defendant, of course they're going to attack the credibility of that witness. And when you have a tape of their voices, they've got to put some kind of spin on it. They've got to explain it somehow, and that's what they will probably attempt to do later today. Now, with regard to that tape and the transcript of that December 11th tape, at page 5, Erik Menendez is heard to say, "Never could she, that is the mother, live without my father." And what they're doing is they're talking about the decision to kill the mother also. They already decided they're going to kill the father, but the decision had to be made what to do with the mother. At page 6, Lyle, again on this issue. Lyle states, that was something that we had to really, it was a big thing holding us back from killing my father, was that we thought we would just kill Dad and eliminate the problem. And then later on, Lyle Menendez at page 17 states, my father should be killed, there's no question. At page 20, Lyle continues, so it came down to that decision, and we decided that my mother could not live without my father. And then at page 21, Lyle states, and it was just a question of Erik and I getting together, and someone bringing it up, and us realizing the value in it. At page 31,
They were also placating to Dr. Oziel in that tape and saying things that they said they didn't necessarily mean because they were just trying to agree with whatever Dr. Oziel, well, not everything. They did disagree with some things, but for the most part, Dr. Oziel was shaping the narrative of everything and telling them, this is why this happened, and this is why you did this, and thinking he knew better. So, yeah, Dr. Oziel tried to shape the narrative, and I think some of that the boys just went with to placate the conversation with him and get him to, shut up, I guess. I don't know how they trusted him. I mean, I know the parents literally picked him because he signed an agreement to basically tell everything, divulge all of Eric's secrets to the parents when Erik had therapy with him. So that alone right there, he should be disbarred, or not disbarred, but decertified, whatever, no longer ever able to work with patients in the healthcare field.
Erik Menendez states, my mother had to be killed. It was the only way out for her. These defendants knew that they were being taped that day. They tried to put the best spin on what they did by saying that they were doing their mother a favor because she was suicidal. As Julon Smith indicated, they were told to try to seem remorseful because someday maybe a jury would hear this tape. On that same transcript, page 42, Lyle Menendez states, there was no way I was going to make a decision to kill my mother without Erik's consent. I didn't even want to influence him in that issue. I just let him sleep on it for a couple of days. It had to be his own personal issue. If he felt the same way I did about killing Mom. Well, they thought about it for a few days, and they decided that she would die too. The decision was made to kill both parents. An agreement was made, and as Lyle Menendez indicated on page 46 of the December 11th, 1989 session, we had to go down wherever to take care of an important issue concerning it. This, I believe, is a clear reference to having to travel down to San Diego to get the guns, an overt act in furtherance of the conspiracy that had been formed. Now, we know that the defendants drove to San Diego and bought 2 shotguns using fake ID and a fake address. Their story is completely ludicrous, that they just happened to be driving down the 405, and heck, they ended up in San Diego, and, well, good place to buy the shotguns. Now, they used fake ID, they used a fake address on top of that. Now, although we know that Lyle Menendez usually used a credit card to make purchases, on August 18, 1989, before the defendants left their Beverly Hills house, they got cash to make the purchase. But the defendants will tell you that they weren't trying to hide what they were doing. Well, why did they take cash? If they had made all these purchases on credit cards all that time, why on this occasion did they have to get their cash? Because by paying cash and using a false name and using a false address, you're not going to get caught. You're not going to be connected to the crime and the guns, the type of guns used to kill your parents. While in San Diego, the defendants also purchased shotgun ammunition. Now, with the guns having been purchased, the defendants waited for an opportune time to kill their parents. They had purchased the shotguns, as we know, on Friday night, August 18, 1989. But there was yet to develop the alibi and to refine it. Now, with the maid gone on the weekends, that Flor Surya came in and testified, with Ms. Surya gone on the weekends, there would be no witnesses if they did it on the weekend. Saturday, we know that the Menendez family went shark fishing, and on Sunday, August 20th, 1989, Lyle Menendez called his friend Perry Berman to arrange to meet Perry that night. Berman told Lyle that he was going to the Taste of L.A., and Lyle told Berman that he and the defendant were going to the movies and would meet up with Berman at the Taste of L.A. after the movie. Now, the defendants had decided to use the alibi that they were at the movies during the murders, and they went to the Taste of L.A. actually afterwards. Now, that's the story that they gave. That's the story that they gave that night to Sergeant Edmonds. In fact, according to Perry Berman, well, Lyle called him at home because Perry Berman waited for them, but had to go home. At about 11:07 p.m., he received a call from Lyle Menendez. Lyle stated that he was at the Taste of L.A. in Santa Monica. Lyle claimed that he and Erik had been there at the Taste of L.A. since 10:15, the approximate time of the killings. And they couldn't find Perry. Lyle asked Perry to meet them at their house that night, that he had to see Perry that night. Lyle testified that, well, he just needed a friend. What he needed is a friend to be there so that that friend could be there when they walked in to, quote, discover, unquote, their parents. It would be a little tidier if they knew that they were going to call the 911 operator themselves and come upon the scene themselves. But it would have been nicer, I suppose, Lyle felt, that if he had a friend there, they could all go in there and make this discovery. Much to the defendant's dismay, however, Perry Berman didn't bite. He said, I got to go work tomorrow. I'll meet you at the Cheesecake Factory, but I'm not going to come all the way to your house. Now, the defendant told Dr. Oziel that there was no way to connect them to the murders. Erik Menendez said he walked into the family room first and Lyle followed. They, quote, surprised, unquote, their parents. Dad said no, 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 and Mom was moaning and did not die immediately. Even after emptying their shotguns into their parents, she was on the floor moaning, crawling, and trying to move. Erik and Lyle Menendez went back to the car to get more ammunition and walked back into the house to finish murdering their mother. The defendant further told Dr. Oziel that they picked up the shotgun shells, exited the house, took all their bloody clothes, put on new clothes, threw their bloody clothes into a dumpster, and took their shotguns 150 feet down an embankment over Mulholland Drive, covered them up, and then drove to the wine tasting party. These are the things that Dr. Oziel testified to. They later returned home and acted as though they were the grieving sons having stumbled upon the bodies of their parents. And they then made the 9/11 call. The defendant indicated and felt that there was no way to connect them to the murders. Erik said that there was no way to link them since the fingerprints in the house would be there since they lived there. No witnesses. No one could link them in any way to the weapons because the weapons he himself had buried. And Erik believed that there was no way to tie them into buying the weapons in San Diego. So there was no way to link them to the murder except now that Erik had spoken to Dr. Oziel. Dr. Oziel, after getting the information from Erik Menendez in that October 31st session, was concerned. He asked if Lyle knew that Erik was going to confess. And he wanted Erik's permission to confront Lyle personally to assess his reaction, to see if he would maybe be in danger with this information, since there was no other way to connect them except for the statement that was made to Dr. Oziel. As we know, Lyle Menendez came in to the session, that he was immediately extremely concerned and menacing. According to Dr. Oziel, he got mad at Erik for telling. Lyle couldn't believe that Erik would tell Dr. Oziel and not tell him first. Lyle told Erik how stupid he was for telling. Now there was someone who knew. Now it wasn't a perfect murder anymore. Lyle said how could they be sure that Dr. Oziel wouldn't disclose the information that would allow them to be convicted. Lyle said he didn't want anybody looking over his shoulder and controlling him, and that's why he murdered his parents. Lyle stated that having Dr. Oziel know this information caused him a lot of concern. Now, just as Erik Menendez bragged to Dr. Oziel about how good a job they had done and how perfect it was, in a taped conversation of the defendant, Erik Menendez, with his friend Craig Signorelli on November 29, 1989, and you were able to, in testimony, get parts of the transcript from that particular conversation, the defendant states confidently, "I've known from the beginning, no clues, no one heard anything. Man, we're talking about special hitmen, special shotguns, and knew exactly what they were doing in and out of that house. No one saw anything, no one heard anything. We're talking serious hitmen." He was proud of how they had done it. They had done a perfect murder, they thought. The defendant testified that he and his brother didn't know what his parents were doing in the room that they bursted into on the night of August 20th, 1989. Erik Menendez would have you believe that he saw some figures in the room, and he started to fire his shotgun. We know that they had already decided that they would kill their parents. We know that they knew their parents were in there, and we know further that Craig Signorelli testified as to statements made by Erik Menendez regarding what he saw that night. Now, the defendants, supposedly having never shot shotguns before and acting in a panic and indeed a snail-like fear, were actually deadly accurate for shooting into what the defendant claimed was haze and smoke. Mrs. Menendez sustained 10 shotgun wounds and Mr. Menendez 5, with only 2 misses which ripped through the shutters of the French doors which were immediately behind the victims. Now, according to Craig Signorelli, and the defendant admitted that he did talk to Craig Signorelli. According to Mr. Signorelli, on September 1st, 1989, the day the computer man and his pregnant wife were at the house, the defendant told him that he and his brother went to the movies and then went home to pick up the defendant's fake ID. That Lyle got the guns and said, "Let's do it." That Erik and Lyle went to the family room, and the defendant was on the left and his brother Lyle was on the right. That the defendant looked into the room and saw his parents sitting on the couch. That's in the TV room. That the defendant was supposed to shoot his mother and Lyle was supposed to shoot his father. That Lyle then swung open the door and shot his father, and Erik said he shot his mother as she was standing up yelling. Now, according to witness Catalani from the LA County Sheriff's Criminalistics Laboratory, he found blood on the bottom of Mrs. Menendez's shoe, indicating she, at some point, was probably standing upright before she succumbed to the hideous onslaught that her sons were administering on her and her husband. Now, Craig Signorelli's testimony is very significant because it shows that the defendant, one, looked into the room and saw his parents on the couch before he and his brother burst into the room, catching them by surprise. And it also shows the planning of the defendants because it shows, and is consistent with the statements made to Dr. Oziel and the December 11th tape, it shows that the defendants had decided among themselves who would shoot who. It also contradicts the defendant's story that he couldn't see anything and was acting on autopilot and in a robot-like state. Now, because of this, the defense went at Craig Signorelli very aggressively, throwing out 3 defense witnesses to try to take the sting out of Signorelli's testimony. they threw out Kevin Whalen, the so-called devil's advocate, who testified that Craig Signorelli couldn't have been with the defendant on September 1st, 1989, because it was he, Kevin Whalen, who was with the defendant on September 1st, 1989, because he picked the defendant up on that date at LAX when the defendant came back from the East Coast. And he remembered that date specifically, and he remembered going to the house, and Erik had listened to his answer machine, and Erik kept his luggage in the car, and then they went home, and they had dinner with Kevin's mother that night, and they talked about the computer man who was there that day, the day that Kevin Whalen picked him up. Well, Kevin Whalen testified he didn't remember any pregnant wife, but he remembered a computer man there the day he picked Erik up from the airport. We heard Kevin's mother, Mrs. Bulow Cohen, and also Kevin's sister was called by the defense, Catherine Whalen. They all three testified for the defense that Kevin picked the defendant up from the airport on September 1st, 1989. They remember that date. Now, Kevin stated that he doesn't remember the date after the day that he picked up Erik Menendez from the airport, however. Now, the defendant himself testified that he came back from the East Coast on the day the computer man came with the pregnant wife to the Beverly Hills house. So there were 4 witnesses that were delegated with the duty of trying to somehow impeach, contradict Craig Signorelli. We know that the computer man himself, Ed Heyman, and his wife also testified here. She was a pregnant lady then. They both testified that it was Craig Signorelli that was there on that day. Yet, these defense witnesses tried to say that the Heymans were off their rocker, they didn't know what they were talking about, that Craig Signorelli wasn't there. They said the whole Whalen clan basically said some not nice things about Craig Signorelli. Mr. and Mrs. Heyman, the computer people, did not ask to be witnesses in this trial. They just happened to be experts called to perform services that day. Nevertheless, both of them, or all 3 of them, were attacked, and the defense was trying to show that Craig Signorelli basically was not there on September 1st because, as I've indicated, Craig Signorelli's testimony is significant in the ways I've noted. Now, when you think about it, how do you show when a person came back on a plane ride, when he came back? Do you go to all the different airlines and have them check and see? Well, after hours of research and review, evidence was in fact uncovered that Erik Menendez did not come back on September 1st, as he testified and as 3 witnesses testified. He came back on August 31st, 1989. He came back from LaGuardia Airport to LAX. And we know that because we know that through the testimony of Pat Heffernan, who was Coach Mark Heffernan's wife, who saw the defendant in New York at the Sheraton, who let Erik Menendez use her American Express card to make the purchase on US Air. And we also brought in Carol Black from US Air, who testified to certain documents from that company, US Air, indicating that indeed Erik Menendez had flown back on August 31st to Los Angeles. And that is Exhibit 292. So this exhibit...
This is very confusing, by the way, and whatever their point is, it's going to be lost to the jury because he's all over with these dates and times, and this person, that person said this, and I don't know. Are you guys following? Plus, it's been so long since we heard from these people that I don't remember the point of them, half of them. So hopefully he like makes it make more sense, I guess. I don't know. I think like this whole part right here with the flights and when he came in, it's all confusing to me, and the computer guy. It's been confusing to me since they testified, but that he's not making it any clearer, and that's what he's supposed to do in closing arguments is make it all come together, and he's not. What do you guys think about his testimony so far? Let me know in the comments below. And also, who here is super excited to hear from Leslie Abramson in the closing arguments? Me, I can't wait. So let's get rolling with his, and hopefully we can get, because I'm going to have to cut this early, but we should be able to get some of Leslie's arguments in. Definitely, we'll get to all of them, but she talks for a while here.
It's a small exhibit, but it's very significant for the ways that I've indicated. Exhibit 400 is another piece of the US Air information, and that is an American Express gold card receipt belonging to the Heffernan showing that Erik Menendez's ticket was in fact purchased relevant to the New York to Los Angeles plane flight. So those are exhibits 292 and 400. Now it's clear that Mr. Heyman and his wife were not mistaken, that in fact the Whalen clan was mistaken, and one would hope that embarrassment prevails in the Whalen home for trying to attack Craig Signorelli and the Heymans in the way they did. We know that the defendant told Dr. Oziel that the defendant surprised their parents and that their mother kept moaning and moving, so they had to reload to finally kill her. That's what Dr. Oziel was told. And in fact, the defendants had to admit that because there were too many shots. I mean, they fired too many shots. They had to reload. They had to acknowledge that they reloaded. In fact, Erik Menendez said that his mother was moaning, so they had to go back out and reload. The evidence shows that Mr. and Mrs. Menendez were sitting on the couch watching TV when they were surprised by the defendants and shotgunned to death. Lyle testified that he put a shotgun up to his father's.
The evidence shows, according to the autopsy and the trajectory of the wounds, they were standing when it began. They later fell to the couch. They were standing originally, which is also weird and suspicious to me that they were just standing there. I feel like they were talking, maybe plotting something against the boys, perhaps figuring out, discussing what to do now that the boys were being rebellious and using this whole essay thing as a, hey, we're going to expose you if you don't stop and if you don't listen to me, trying to blackmail him with it. And so I think that they were probably plotting something. Maybe not the end of their lives, Erik and Lyle, but perhaps something to get to rein in the control and to get them back in under their thumb. So possibly that's my speculation.
Head, and it was he who put his shotgun also up to his mother's cheek and delivered the contact wound blasts to them. According to their statements on December 11th, 1989, and in that tape, the defendants had decided to kill both parents. Clearly, when they entered that room, that family room, on August 20th, 1989, they intended to kill their parents. The defense may attempt to argue otherwise, but it's clear from the evidence that they intended to kill their parents. They fired their pump shotguns into their parents, and in fact, the defendant testified that after he and Lyle emptied their shotguns, they ran out to the car, and the defendant, without even talking to his brother, knew, and testified that he knew, that Lyle would return to the room to kill their mother. Because they already planned that this is what they were going to do, and her laying there moaning, that wasn't going to cut it. She might survive. They knew they had to kill both parents. So what does Erik Menendez do? He says one cartridge to his brother, with which to deal that fatal blow to his mother and stop her from the possibility of her surviving the attack. Clearly, the defendant intended to assist in the killing of his parents. Now, Dr. Oziel, Craig Signorelli, and statements made by the defendants from their own mouths on December 11th, 1989, statements that they'll try to put a spin on, but they're in their own voices, establish that the defendants clearly intended to kill their parents, and indeed, they made sure that the parents would not survive the shotgun attack by administering contact wound blasts. So if you look at the crime scene and you look at what they did, it's clear what their intent was. They weren't going to leave any survivors. In fact, you've had testimony that these photographs indicate that there was UCLA paperwork, blood spattered next to the mother. There are no weapons next to the parents. In fact, Kitty Menendez's friend came in and testified, Karen Farrell, and she said that they had planned to play bridge with Mr. and Mrs. Menendez that night. There was no plan to kill the defendants, as they have attempted to claim. Judalon Smith. Judalon Smith testified that she heard Lyle yelling at Erik in Dr. Oziel's office, and she confirms that Dr. Oziel called his wife to warn her, a psychologist, a lawyer, and also a police station for advice. Does this sound like something that a man would do that's been threatened? Now, Dr. Oziel indeed justifiably felt threatened by the brothers, and indeed the courts have ruled that the exception applied to the October 31st and November 2nd sessions, allowing Dr. Oziel to testify as to those sessions.
Right. Judge sustains that portion of the remarks regarding the court rulings. Jury's admonished to disregard it. You may proceed.
Dr. Oziel wanted to get the defendants on tape, as Judalon Smith indicated. And why did he want to do that? He wanted to do that, as she testified, for his protection. That if you get him on tape, he had told them he had him on tape for his protection. He had an insurance policy that don't do anything to me because I've given these tapes to my lawyers, and if I get killed, you're going to be found out. Dr. Oziel wanted their voices on the tape. Now, Dr. Oziel, according to Judalon Smith, had told the defendants that they would be recorded for their own benefit if they ever get caught.
Yeah, right.
He indicated that they should show remorse on this tape.
He just wanted to blackmail them.
And Dr. Oziel really wanted it to protect himself and Judalon. Judalon testified. Protection from the defendants. Now, after the defendants were finally put on tape, Dr. Oziel felt somewhat relieved. He had a pretty good insurance policy at that point. Now, does it sound...
Yeah, exactly. He blackmailed them. He recorded them so he could have some kind of tool to keep them in line and use them for the money that he saw them as, just big old money bags, because that's all he cared about. He charged them for attending the funeral. If that doesn't say it all, I don't know what will.
Consistent that a helpless, poor, abused set of brothers would threaten their psychotherapist who found out about the killings? Or does this sound more consistent with cold-blooded killers? With regard to Judalon Smith, there was testimony about an affidavit that she submitted to the Superior Court in Santa Monica. And at page 21-234, part of that affidavit was testified about. And what it stated, and this is an excerpt from that affidavit, signed under penalty of perjury by Judalon Smith. I was also particularly concerned because after hearing Lyle threaten, now we have to kill him and anyone connected to him who knows we're connected to him, end of quote. I had heard the threat to include references to the secretary because there's a secretary that you go through to make appointments. Further, regarding that same affidavit, at page 21,237, and this appears to be at page 18 and 19 of that affidavit by Judalon Smith, planned to kill their mother and father as they were themselves watching TV at home. So this goes to what the judge will later instruct you about lying in wait, that they planned for an opportune time to act. They'd come in and surprise their parents, and there was a period of watchful waiting which preceded the killings.
That's so ridiculous when you listen to their testimony, the boys talking about how they got into a confrontation with Jose. So there was no lying in wait. There was the confrontation where Jose told Erik to get upstairs because he wanted to have his way with Erik. And the boys were also thinking that they were in trouble because Erik told Lyle about the SA and they had threatened to out him publicly. And he was not going to have that. So this was what caused them to react. It wasn't a lying in wait situation.
Now the affidavit continues, and it's testified further at 21,238. The father either died instantly or quickly, more so than the mother, because they described the mother as continuing to move or gasp and make sounds, and that they had to just really keep shooting and shooting her. Well, yeah, they did have to keep shooting her, and we know that she had 10 wounds on her. She wasn't standing still for them to get to a vital area. She was getting blasted all over that room. And when she finally got to where she was laying on the ground moaning, that's when they put that final blow into her. So indeed, when she indicates that the mother kept moving and they had to keep shooting her and shooting her, that's borne out by the evidence. Judalon Smith was also examined by Mrs. Bazanich regarding the Diane Sawyer, that primetime segment that she did. She was asked, and this is at page 21,154, she was asked by Diane Sawyer, are Lyle and Erik Menendez guilty? Did they murder their parents? Judalon Smith says, yes, they did. Diane Sawyer says, you know this? Judalon Smith answered, absolutely. I heard from their own mouths that they killed their parents. And then it goes on. Were they proud of it? Judalon Smith stated, absolutely. They felt they had committed the perfect crime.
Those are also Oziel's words. So I'm sure she felt that, hearing it over and over and over again from Oziel, that she thought she heard that. She thought she heard them say it because Oziel probably said it over and over.
One of the things, and this is Judalon Smith again, further in the program. This is a Diane Sawyer primetime program, by the way. And this is at the bottom of 21,154 and goes on to 21,155. Judalon Smith states, one of the things that I heard Lyle say that was really disturbing to me, this is a sum of and the essence of what he had said. Well, for once my father would have to congratulate me and give me credit that I planned the perfect murder. I carried out the perfect murder. With regard to Judalon Smith, there's testimony.
We never heard that on the tape. So that was never recorded. So it's really convenient to use it as a quote to convict them.
That she had testified under penalty of perjury in front of Judge Albrecht in the Superior Court of Los Angeles in Santa Monica. And that testimony is reflected in pages 21,159 through 21,164. And part of that testimony was Judalon Smith acknowledging that she testified under oath in front of Judge Albrecht on July 30th of 1990. And in that case, certain hearings were being held in Santa Monica, and there was a question by the court, that is Judge Albrecht, of Ms. Judalon Smith. At some point, did you learn of there allegedly being threats from the Menendez brothers to Dr. Oziel? And after some exchange, the answer was, I directly heard them make the threats. The judge then asked, do you recall the date on which you first heard such a threat? Julon Smith's answer was the night of October 31st, 1989. The judge then asked the question, and where did that occur? Julon Smith answered, at 435 North Bedford, the offices of Jerry Oziel. The judge, Judge Albrecht, then asked, and at whom were those threats directed? The answer by Julon Smith, to Jerry Oziel. The question by the judge, and could you tell who was making the threats? The answer by Julon Smith, yes. She goes on to state that the threats were made and she could hear from inside the room where the defendants were with Dr. Oziel.
This did not happen this way.
She goes on to state at 21,164 that all there was separating her from the two defendants and Dr. Oziel was the door. And she could hear, the judge asked, Judge Albrecht asked, could you hear clearly through the door? Julon Smith answered yes. The question by the judge, could you hear people in the other room if they were talking in a normal tone of voice? The answer by Julon Smith, from the other side of the door, yes. Judge Albrecht then asked, could you tell who made the first threat? Julon Smith said yes. She was then asked by the judge, by what means could you tell? Julon Smith answered by the context of the conversation. The next question asked by Judge Albrecht was, do you want to tell me a little bit more about that, how you arrived at that conclusion that the threats were being made? The answer by Julon Smith was, well, because Lyle was angry at Erik for coming to tell Jerry about his parents. He yelled and said he didn't have a brother anymore. He could kill him. Look at all the trouble he had caused, and now he'd have to kill Oziel and everybody connected to Oziel and everybody who knew. That's how Julon Smith testified in front of Judge.
And she was also influenced a lot heavily by Dr. Oziel. And on the stand here in this trial, those aren't the things that she testified to.
Albrecht in 1990. And as I've indicated, there was an excerpt from the affidavit submitted under penalty of perjury by Julon Smith. Now, we know that the defense called Julon Smith in to testify. We know that there was a lot of acrimony between Julon Smith and Dr. Oziel. And we know she now has different memories, but this is how she testified in 1990. Now, there is...
Well, she was still under the control of Dr. Oziel.
A lot of evidence about the defendant's desire to kill his father. The defendant, in his testimony, said that his father told him what he would do and be in life, what he would do in sports, what he would do as work. Mr. Menendez put pressure on the defendant. The defendant didn't like that pressure. Mr. Menendez even had plans for Erik and Lyle to move to Florida to live in a family compound, kind of like the Kennedys. Now, Erik Menendez told you in his testimony that he was told that he was out of the will in September of 1988, which coincidentally occurred about the same time that Mr. Menendez was accompanied Erik Menendez to the Los Angeles County Sheriff's Department in Malibu about those burglaries, the burglary and grand theft that Erik Menendez had committed. Of course, Erik Menendez said, well, that really didn't have much to do with my being disinherited. It was because I dropped in my rankings in tennis. You also heard Erik Menendez say that in May of 1989 that his father wanted to disown him. Erik feared, all right, he feared that he would have to get off of his butt and work just like all the rest of us. And his father was going to cut him off and just say, you know, if you can't abide by my rules, then you can go ahead and live on your own.
Erik and Lyle were always expected to work. So he never didn't expect to work. There was never a time where he expected to just live off of his father's money. He was expected to go work, I think, in his father's businesses. And I don't know what Lyle was supposed to do, but I think Erik was supposed to come work for him, or work with Jose.
Erik obviously didn't want to get kicked out. In fact, he said he didn't want to get kicked out. He didn't want to get disowned. But he didn't want to do what his father had as far as the rules of the family. He didn't want to toe the line. And as he testified, he said that things were changing. And in cross-examination, he said his father was starting to cut off Erik and Lyle. He was starting, and they were adults. You know, there's a time at which you have to go away from your parents. I mean, there's a time at which if you're going to be an adult and live with your family, with your parents, you can't just have your own rules. And if you don't want to abide by them, then you shouldn't be there. The defendant continues with this sentiment in the December 11th tape. At page 1, the defendant starts out, actually it starts the tape off. The defendant, Erik Menendez, states, yet we thought that no matter what we did in our life, my father would be there, and that it, unintelligible, related to Kennedy. When Kennedy was president, his father told him that he wanted Bobby in this position, and it did not matter what John said. And we thought that whether we became the senator or whether we made hundreds of millions of dollars, it would all be because my father was this incredible man and we were just, and the word is either pushed or privileged. Erik Menendez goes on to say, and the pressures, and there was no question about that. What the defendant is saying that his father would always be calling the shots. It didn't matter if he were to become the president or a senator of the U.S., that his father was there, he would push him, he would tell them what to do, and the defendant didn't want that pressure anymore. He didn't want to have to put up with his father anymore. Also on the December 11th, 1989 tape, the defendant responds to Dr. Oziel's observation that Erik was about to go to college. Erik Menendez responds, by going to college, I mean, it didn't matter. Even if I was in college. I remember when I was in college, I wanted to major in act in theater, and my mom wanted me to major in theater. But couldn't tell me that because she was an actress, and she was a great actress. And so she had this love for theater. And when she saw me at stage when I was at Beverly, she loved it. And she wanted me to major in it. But I couldn't even bring it up to my father. I did once, and it was he thought I was kidding. It wasn't even something that was going to even be brought up. And my mom certainly would never bring it up. And so what I was doing, what I was taking, I wasn't even going to decide. It was my courses. When I had an hour or two to select my courses, I would already have the sheet and already have it worked out, and my dad would already have worked out what I was going to take. What Erik Menendez is saying that is he felt that he had to get out of the control of his father. His father just made all the decisions.
And that's a problem, don't you think? Having your father make all the decisions for you in your life, that is controlling, manipulative, abusive BS. And yeah, I'd want to get away from that too. He just didn't know how.
Even on what he was going to take in college, where he was going to live later, who he'd live with. The decision then was made to kill both parents, and that is reflected on this December 11th tape. But that is a choice that the defendants made, and they should be held responsible for making that choice.
All right, are you moving on to another section?
Yes, I have another section that I was going to start on.
What we'll do is take our recess at this point, and we'll resume at 20 minutes to the hour later.
At this point, and as you know, go over a couple of jury instructions. The judge will instruct you on the law at the close of arguments. And as you know, you're the judges of the facts. But with respect to the law of murder, the judge will instruct you consistent with what is here, and that is the elements to be proved in a murder. The first element is that a human being was killed. The second, the killing was unlawful. And the third, the killing was done with malice aforethought. Clearly, the first, Jose and Kitty Menendez, it's clear that that element is established. With respect to the killing, there will be no claim that this was a lawful killing. And with respect to number 3, malice aforethought, the judge will instruct you what the definition of malice aforethought is. And for express malice, malice is expressed when there is a manifested an intention unlawfully to kill a human being. So when it's an intention to kill. So to show malice aforethought is a simple matter of showing an intent to kill. You'll be instructed with respect to malice aforethought, the mental state constituting malice aforethought does not necessarily require any ill will or hatred of the person killed. The word aforethought does not imply deliberation or the lapse of considerable time. It only means that the required mental state must precede rather than follow the act. That is, the intention to kill. With respect to the charges in this case, the defendant is charged with 2 counts of murder of Mr. and Mrs. Menendez. But in order to affix the degree of the murder, it's relevant to, and the judge will instruct you on deliberate and premeditated murder. And that is, or will be defined as all murder which is perpetrated by any kind of willful, deliberate, and premeditated killing with express malice aforethought is murder in the first degree. The word willful, as used in this instruction, means intentional. The word deliberate means formed or arrived at or determined upon as a result of careful thought and weighing of considerations for and against the proposed course of action. The word premeditated means considered beforehand. To constitute a deliberate and premeditated killing, the slayer must weigh and consider the question of killing and the reasons for and against such choice, and having in mind the consequences, he decides to and does kill. As we have reviewed the evidence, the defendants weighed their decision to kill. They spoke about the considerations to be made after watching the Billionaire Boys Club. They talked about killing their father. They came to the decision that they would kill their father. They had to discuss, as they indicated on the December 11th tape, further discussions about whether or not they would kill the mother as well. So there were these discussions taking place, which you can consider to be they're premeditating and deliberating over whether or not they were going to kill their parents. There's another instruction. There's 2 special circumstances alleged. One is multiple murder, and that's a simple instruction. That is, if you find murder, and at least one of the murder counts is first degree, then the multiple murder special circumstance applies. And you'll find that to be true then. With respect to the line and weight special circumstance, there will be given a rather lengthy instruction on line and weight. In part, you will be instructed that line and weight is defined as waiting and watching for an opportune time to act. Either a concealment by ambush or some other secret design to take the other person by surprise. When a defendant intentionally murders another person under circumstances which include concealment of purpose, a substantial period of waiting and watching for an opportune time to act, and immediately thereafter a surprise attack on the unsuspecting victim from a position of advantage, the special circumstance of murder while lying in wait has been established. You'll be instructed about all the law in this case. Not all of it may be applicable, but you'll be instructed by the judge later in this case. I think those are the instructions that will be dispositive in this case. Next, I'd like to turn to an analysis of the defendant's story regarding the events of the week prior to the murders. That is, what did they claim led up to this, the killing? First of all, the defendants claim that on August 15th, 1989, it was a Tuesday, Kitty Menendez pulls off Lyle's wig and makes him cry. There's a big argument with yelling and screaming, and the defendant, for the first time, learns of his brother's wig, and as he testified, he decides to share a moment with his brother and tells his brother about the molestation. What we have in that regard is, first of all, they never told the story to anybody until you heard it here. I mean, they didn't tell the story to the police when they were arrested. The story didn't come out to any of the newspaper people that they lied to, the relatives that they lied to. What, in the analysis of that particular part of their story, their version, the people put on Jamie Pisarcik, who testified that the defendant knew about the wig before the murders, she believed in the spring of 1989. Ms. Pisarcik, when pressed, remembered seeing Hurley-Burley at the Westwood Playhouse. She believes during her stay, when Erik says it told her that he knew about the wig. Well, we know through the stipulation that Hurley-Burley, in fact, played there at the Westwood Theater from November of 1988 to January of 1989. We know that Flor Surya, the maid, didn't hear of any such screaming or yelling, and she was there on August 15th, 1989. The next part of their story of the week preceding the murders was August 17th, 1989. The story is that Lyle confronted Jose about molesting Erik. Jose says he will do what he wants, and late at night, Jose attacks Erik and bangs on Erik's door, yells at Erik, tries to molest Erik. Erik escapes the struggle, and he indicated he really got into this story. He's saying that the typewriter flew off the desk, and there was a big rigmarole, and he was thrown on the bed. And then he goes downstairs, and his mother happens to be sitting in the TV room. So he happens to just have a chat with her. He discusses with his mother his problems. She says she knows. Erik says, I hate you. After first she asks, what's wrong with you? Mother says, you bastard. There's yelling. And this, as you know, is in the room right next to where Flor Surya is staying. She's sleeping. This was on a Thursday night. She didn't leave until Friday. Of course, the defense brought in witnesses and say, well, I didn't hear yelling and screaming. Mr. Slotkin, I didn't hear yelling and screaming, but on cross-examination, he said, well, there wasn't yelling and screaming in my house, so I guess I wouldn't know whether there was yelling and screaming. Flor Surya, who actually lived in that maid's room, testified that she could hear the television from the next room over, the TV room, which is right next to her room. And this is where supposedly this yelling was occurring. In fact, Lyle Menendez testified that he could hear the yelling and screaming from the guest house. And from those photographs, you could see how far a distance it is from the rear of the house. You have to go past the tennis courts and the pool to get to his guest house. So there must have been, according to them, some really loud yelling and screaming. Yet she heard none of that. The next leg of this story that they made up is that on August 18th, the defendants get up early, they get their cash together, they go to the Santa Monica Big Five to buy handguns. The defendant claims to have been directed to the real handguns, and he and Lyle select the real handgun. And when ready to make their purchase, they are informed they cannot leave the store with the handguns because of the 2-week waiting period. Well, we know first of all that Mark Heffernan, the coach, testified that he gave Erik a lesson, tennis lesson that morning on Friday, August 18th, from either 9 to 11 or 9:30 to 11:30. And you know from Erik's testimony, he went early in the morning, and he was there at this Big Five store in Santa Monica that morning. We know further that Big Five does not carry handguns and haven't since March 1986. But of course, Erik Menendez tries to weasel out of this lie too. What does he do? This happens on a Friday, the testimony about the Big Five, and him getting caught in that lie. And of course, he has time on the weekend to think about this, and he comes back on Monday, and he starts to say, well, you're the one that says, as I'm cross-examining him, you're the one that says it's a Big Five. And I said, you're the one that said it was a Big Five. Not only did he testify as a Big Five, his brother testified it was a Big Five. In fact, his own attorney came back and said, are you sure you're at the Big Five? Oh, positive I'm at the Big Five. No question about it. Well, the defendant comes back, and they put on some fancy photographs, a series of photographs. They bring in a couple of witnesses. To say what? To say that there were guns there? No. They didn't say that, but they have to bring some people in to kind of confuse things for you. So it's clear that there were no handguns in Santa Monica at the Big Five store that day. But what the defense then tried to do, the weasel out of this one, is upon being questioned by Mrs. Abramson, Erik Menendez is asked, well, was the clerk kind of helping other people? Maybe it was the clerk's fault that he thought that there were real handguns there. Maybe he misled this poor defendant. Maybe it's the clerk's fault. Clearly, Mark Heffernan remembered that lesson that morning, and they weren't at the Big Five store in Santa Monica trying to purchase these handguns. The fourth leg of this fantasy is on Saturday, August 19th, 1989. The defendants get up, according to them, and they leave the Beverly Hills house, and they are shaking in their boots. They leave the house because they're afraid their parents are going to kill them. What they do is they leave, and they're gone the whole day. But what do? They come back, and they're supposed to go to the fishing trip. And they're thinking, oh, well, maybe if we stay out long enough this whole day, our parents will go. And then we won't have to go shark fishing with them. Because, heck, we wouldn't want to get killed on that fishing trip. Well, they come back. They say they're gone the whole day, and they come back, and their parents are coming out to go on the fishing trip. About 4 o'clock, 4:30. Well, we know from the pool man who came in and testified. The pool man, actually the repairman who was just there that one day, he worked on the heater. His name's Grant Walker. Grant Walker is sure he was there on Saturday, August 19th, 1989, at the Menendez house. In fact, the regular pool guy who serviced the pool, Leon Bartek, he was a regular serviceman, is the one that asked Mr. Walker to do the service. So it's not like Mr. Walker came in off the street to say, hey, I was there that day, and I saw them being abusive and cussing in front of their parents and all that. This man was there. He was working on their pool. And that's what the evidence shows. And what he says, what Mr. Walker says, is that he saw the defendants at the house in the afternoon on Saturday, August 19th, 1989. And their story is they were gone the whole day because they were so afraid that their parents were going to murder them. At about 2 o'clock in the afternoon, the defendants, Lyle is on the tennis court, Eric's next to his parents. Defendants are using profanities in the presence of the parents. Walker is so disgusted, he tells his wife how disrespectful the defendants were to their parents. Now, the defense tried to impeach Mr. Walker by calling one of his customers, Mrs. Valdry. Well, Mrs. Valdry corroborates Mr. Walker about being a customer of his and establishes further that Mr. Walker was correct when he said that he serviced her pool on Saturday. Now, she says that he started in 1987, that for about 2 or 3 weeks or so, he had to work with the chemicals, and he was coming during the week. But after that, she said he came on Saturdays. Well, the defense, what did they do with that? They're the ones that called this witness. Well, they tried to say that she didn't know when this man came. They brought in their defense investigator, and the defense attacks Mrs. Valdry and claiming that she's angry at them. That's why she lied. Well, she didn't lie. She said that she never told the defense investigator what the defense investigator testified to you. Who has any reason? I mean, would Mrs. Valdry have a reason to come in here and lie to you about that? You'll make that determination. Furthermore, with respect to Mr. Walker's testimony, Mr. Heffernan, the coach, corroborated the fact that the parents would pull chairs, although he had never seen the table in that area between the pool and the tennis court. But Mr. Heffernan said, yeah, the parents would bring the chairs over and watch the brothers play tennis. And that defense, yeah, would cuss on the court. And Heffernan testified earlier. He came back a couple times in this trial. He had testified that the defendants were big, strong, aggressive athletes. These guys were not young kids. Now, the question is, how
They're not young kids. 21 and 18. Granted, that is adults in the eye of the law, I guess. But our brains aren't even formed all the way until we're about 25. So you're still doing impulsive things. You still think like a teenager in your early 20s. It's not until your brain fully develops where you lose that like impulsive teenage rebellious phase. So, plus, and I've said this in other streams, that the boys were so badly maltreated that psychologically, emotionally, they were very stunted. I believe Lyle, someone said in a post somewhere that Lyle was about 10 years old psychologically and Erik about 8 due to the severe trauma that they had been through.
How would Grant Walker know all of this unless he was there and saw it? He was there one day. How would he know that the parents, on occasion, would bring the chairs over and watch their sons? Unless it happened, unless he was actually there. Nevertheless, when a witness testifies and the defense believes it may be damaging, they're going to attack that witness. In fact, they did that to Mrs. Valdry when she substantiated what Mr. Walker had said by saying that she was angry with the defense. And we know that once the people got the report, in fact, Cindy Early, the defense investigator, had in her notes that Mrs. Valdry was a cooperating witness, not angry as they tried to claim. Next, I'd like to turn to the post-crime, the post-murder driving situation that the defendants testified to. Now, the defendants claimed that, they didn't think about this, they didn't plan this all out. In fact, after they massacred their parents, they sat around waiting for the police to come, twiddling their thumbs. In fact, Lyle testified that they sat there for 5 to 10 minutes waiting for the police, and then, heck, they got tired of waiting, and they started to discuss among themselves. Hey, maybe we can get away with this. So they had a discussion for a couple minutes, then they decided to pick up the shells. They picked up the shells, that was another minute. So let's go over what the defense says about this, what happened during that period of time. Now, first of all, the defense put forth 2 routes, one route being travel to Mulholland, and then after Mulholland down to the theaters, and then to the Santa Monica Taste of LA. Well, neither brother testified to that. Lyle testified that he thinks that they went to the theaters first and then to Mulholland. In fact, Erik Menendez testified that they went to the theaters first, then to Mulholland, then to Santa Monica. So the relevant one would be Route 2. And it was marked as an exhibit testified to by defense investigator Early. That would be exhibit number 358A. What we have and what this shows is that there was a lot of speeding going on to try to come in within this time. And there's an overall time of 50 minutes. So giving the defendants the benefit of saying that the murders occurred at 10 o'clock and the call to Perry Berman occurred at 11:07, that gives 67 minutes. So what we then have is, for example, the defense in this Route 2, an overall time of 50 minutes. That is driving time from Beverly Hills house to the theaters, to Mulholland, and then to Santa Monica. For example, defense investigator Early was going 40 to 45 in 25-mile zone on Coldwater, et cetera, et cetera. You can take a look at the exhibit. So they try to make it, try to go pretty fast to try to make it so they can fit within that time. But if you look at Lyle Menendez's testimony, and you look at the time allotted by the defense in this exhibit, what they call activity time allowances. And when Ms. Early testified, she said, well, I didn't really have the testimony. Mrs. Abramson told me what times to plug in. Okay, so let's see what times she was ordered to plug in. There's an overall time of 4 minutes for after the shooting. This period of time that Lyle testified that they sat around waiting for the police 5 to 10 minutes before they even started to discuss the possibility that they would not get caught. Taking a couple minutes. Picking up the shells would take about a minute. What we're looking at there is 8 to 13 minutes just there, according to Lyle Menendez. What happened, though, is they wanted you to think that they were waiting around. They really didn't work like clockwork and do all these things. But once it was crunch time and they had to determine, well, can we really have done it during that period of time? Then they're going to start shaving time off. And in fact, they went from 8 at best, according to Lyle's testimony, to 13 minutes. They accounted for that in 4 minutes. That is to have the discussion, pick up all of the shells, make sure the shells that had their fingerprints on them. So we're talking about taking off 100 to 200%. So we then go next to what they did at the theater. Now, Lyle Menendez testified that they parked at the parking meters at the Century Theater, 14th Theater. Well, there are no parking meters there. And he said it took about 10 minutes. Well, let's see what the defense says they allotted the activity time. Well, that's 4 minutes. They allotted 4 minutes for that. And, okay, to throw the guns out of the car was a couple minutes. Okay, that one's okay. Lyle Menendez testified it took a couple minutes. Of course, taking a couple minutes, going down 150 feet on the side of a road and going down there with 2 shotguns and then having to bury those guns and then having to come back up. 2 minutes is pretty quick, but they didn't say, well, that's not reasonable, let's lengthen that. They said, okay, we'll go 2 minutes on that one. So that one was okay. Now next, they went to a gas station and they threw away their bloody clothes, and according to Lyle Menendez, that took 5 minutes. They've accounted for that as 4 minutes. And getting lost at the Taste of LA, having to look around to find Perry Berman, and then having to find a phone, they allotted 2 minutes for that. So what do you know? Their totals work out to be 66 minutes, and they're allowed 67 minutes. So they could put in whatever times they want to, but it doesn't comport with the way Lyle Menendez testified, because if you plug in the times that Lyle Menendez testified to, then they would have been well beyond their allotted time after just going to buy the tickets and waiting around for the police to come and catch them. So that may give you an indication of Cindy Early and whether or not she has a reason to kind of color what she says, as opposed to Mrs. Valdry, who said that Grant Walker always came during that period of time after the initial time on Saturday. Next, I'm going to turn to some of the things that the defendant did in the week and weeks after the killings. According to defense witness, this is a defense witness, Roger Smith, during the week of the murders at a meeting at Live, Smith, who was then the chief financial officer, informed the defendants that they would not get the proceeds from the $5 million insurance policy on Jose Menendez that the company had purchased. It was because Jose had not taken the required physical. Now, the defendants want you to believe that they knew prior to killing their parents that they were aware of the fact that their father had not taken the physical. The defendants claim that their father had announced to them somehow, hey, I haven't taken my physical, so I don't have the $5 million policy yet. But Mr. Smith testified that after...
No, they knew it because Kitty would nag Jose about going and getting it done all the time. So that's how they knew that he hadn't done it yet.
After the murders, he was the one to inform the defendants of their not being entitled to the proceeds of the $5 million policy. And we know from the tape of December 11th, 1989, that Lyle Menendez had worked at the company for a period of time and was saying how he knew what kind of compensation his father was getting. In fact, knew more than the mother knew. What was the reaction of defendant Erik Menendez to this information being told by Roger Smith? Well, the defendant's reaction was, and the $15 million policy in favor of the company, was that in order? With regard to the post-murder spending, we know that from his statement on September 17, 1989, Erik got an allowance of $180 a month. 4 days after the murders, defendant and Lyle bought Rolex watches and money clips. As Mark Heffernan testified, after the murders, Erik's spending was absolutely on a much larger scale. And we know further from the testimony that on November 29, 1989, the defendant talks about buying a house in Beverly Hills for $8 million. We further know that Erik Menendez made an offer on a house in the Silver Strand area of Marina del Rey for $1.1 million in early 1990. We know that Erik Menendez bought a new Jeep, he bought a pool table, bought new furniture. And we know that on November 29, 1989, Erik Menendez spoke of starting a corporation like the BBC, as in Billionaire Boys Club. We further know that there was some movement by Erik Menendez, according to Mark Slotkin, who was trying to advise the defendants about their investments. Erik was interested in some kind of a concert promotion. Now, as you know, the defendant is charged in count 1 and count 2 with murder, and in count 3 with conspiracy to commit murder of his parents. And it's charged in the information. There are, as I've indicated, 2 special circumstances, the multiple murder and lying in wait. And on behalf of the people of the state of California, I'm going to ask you to find the defendant guilty as charged in the indictment. Thank you.
Oh, it's the blue jury.
All right. Blue jury, Eric's jury, is going to be hearing from Leslie Abramson, the defense attorney for Erik. So here we go. I'm looking forward to this.
I could have sworn I was just listening to a final argument to the gold jury for Lyle Menendez. And even before Mr. Kuriyama did what I knew he was going to do, which is try to blur the lines between what Erik did and what Erik said and what Lyle did and what Lyle said, I knew he was going to do that. And I was concerned that through the course of this trial, you've heard a lot of evidence that had to do with Lyle and his personality and things he said and things he did. And I wanted to make sure that you understood that you are not the blue jury, not only because you giggle and laugh back there all the time and we can hear you. You are the Erik Menendez jury. And in a strange way, in the way that people come together in courtrooms, in this artificial way, you belong to him and he belongs to you for now. Now, when you go back to your real lives, the more normal ones, where other people don't keep you waiting all the time, the notion that you are somehow affiliated with Erik Menendez will fade. But the decision that you make governing his life will never change. And it's a decision that all of you who actually deliberate and render a verdict in this case will live with for the rest of your lives. And from what little we know about all of you, from the jury selection process, I think all of you want to be very comfortable with that decision. I have left these here on purpose to talk about what you are and aren't supposed to do as jurors. And when we say supposed to do, some of these rules have to do with purely legal concepts, but others have to do with easier things to understand, such as the fact that jurors are human beings, and they have consciences like other human beings, and they have to live with their consciences. And we want to make sure that jurors make decisions that are based both on the law and on what is, in any sense of the word, moral. And the very, very first instruction, when the judge reads, which will be a rather large pile of instructions to you, says this: you must not be influenced by pity for a defendant or by prejudice against him. You must not be biased against the defendant because he has been arrested for this offense, charged with a crime, or brought to trial. None of these circumstances is evidence of guilt, and you must not infer or assume from any or all of them that he is more likely to be guilty than innocent. You must not be influenced by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. These photographs are here right now through Mr. Kuriyama's entire argument for no other reason but to upset you and inflame your passions, because they are ugly. Death by shotgun is ugly, no matter what the reason for it. And photographs like this, which we in the criminal law business have looked at, I personally, 23 years of doing murder cases, I've seen a lot of dead people. They are always horrible, and I think I know why, and maybe you would agree. God didn't mean for our bodies to be opened up in this fashion. And when they are, it looks terrible. There's a lot of blood. It's disfiguring. And it reminds all of us of our own mortality. So it's always a cheap prosecutorial trick to put up these dreadful photographs in the hopes that it will so inflame you against a defendant that you'll forget to ask the important question, which is, why did this happen?
Exactly.
And not only why did it happen at all, but why did it happen when it happened? Because in any case charging crimes as serious as murder, and in the specific crimes that you're going to be instructed on here, there must be a joint operation, as the law says, between what a person does, the act, and why they do it, which is either their mental state or their intent. And strangely enough, when you first approach this theory of criminal law, this struck me as odd even in law school, what you do is not enough to render a judgment of what crime, if any, you've committed. You have to have the right, or in the actual term, the wrong attitude or mental state. And that's called, in law school, mens rea, okay? Which is the mental part of any crime. Mr. Kuriyama showed you briefly the definition of murder. To me falls the unpleasant for you task of having to educate you in the law of homicide in great detail, and I have a huge number of charts over there to do it with, but we're not going to do that right now. Maybe I won't even do it until tomorrow, because I am going to be talking to you for a long time. I am not going to ignore any of the evidence in this case. I'm not going to run away from it. We didn't do that during the course of the trial. Every piece of evidence that was testified to that was bad for us, we met head on, we cross-examined on it, we wanted you to weigh and consider whether every piece of evidence was believable. We did not do what the prosecution did, which was run away from the evidence that they could not deal with. And that was the evidence of extensive, disgusting, to use his word, perverted sexual abuse that took place inside this family for 12 years. Mr. Kuriyama did not ask one single question of Erik Menendez on the sexual abuse. And I will explain to you a little later in detail why that was true. All of Erik's life, as you heard from, we called 50.
I mean, first of all, I just want to say I love her. Second of all, like she just comes out swinging and saying, well, we're not going to do what the prosecution did, which is hide the ball. This is great.
58 witnesses. They weren't all witnesses who had to do with his family background, but a great many of them were. But all of Erik's life, he was overshadowed by his brother Lyle. All of Erik's life, he was the lowest man on the totem pole of that family. Lyle, who I believe, and I believe you believe, loves Erik, gave perhaps the most poignant testimony about that when he said that even when he was small, he could see that the way Erik was treated in that family was so bad, he was so ridiculed, he was so belittled, he was so ignored in any meaningful way by his father, that to Lyle, the worst thing he could have been was Erik. But all of his life, Erik has been in the shadow of Lyle. And he put himself there many times. He would say, and he testified, I would stand behind Lyle, because Lyle could be the intermediary with the parents that Erik could not deal with at all. And that's fine. That gave Erik some protection. That gave Erik some ally during his growing up years. But in this trial, the decision that you made affects Erik, not Lyle. And if you decide Erik's guilt based on evidence or information that has to do with Lyle, I can assure you, Lyle will not serve his prison term. Lyle would not go to the gas chamber for him. Whatever you do impacts Erik. And he has a right. He has this much of a right, after all the years in which he was second rate and second best and last to be considered, to have you give him the respect, criminally accused defendant that he is, to judge him for who he is. Because that's what this case really is about. These people are dead and they were killed by their own children. Now, you have to ask, if you knew nothing else, what went on in that family for that to happen? Mr. Kuriyama wants to tell you about 2 or 3 little things that went on in the last year and nothing from before. But nobody is created between the age of 17 and 18. We're created from the time we're an infant, from the time we're a newborn. And so what we tried to do in our case is explain how could these people be killed by their own children? What was it they did? And more important, who did the children turn out to be? Mr. Kuriyama has already resorted to some name-calling. I suspect that in his next argument, because indeed he gets to argue to you again, there'll be a lot more name-calling. But so far he has called Erik a vicious, spoiled brat, something close to that. He should have gotten off his butt, I think he said, and gone to work. He has proposed a theory of premeditated murder that is based on a theory of why these crimes occurred that is completely obscure right now. Let's go back in time in this case. This started out theoretically as a killing for money. Well, Mr. Kuriyama didn't actually tell you. They killed him for the money. Perhaps because we so completely demolished that theory during the course of the defense case that he knows he can't make that argument with any conviction. But in spite of the fact he didn't tell you it was a killing for money, he nevertheless wants to talk about insurance policies that the defendant knew didn't exist, and he wants to talk about post-crime spending. So I will get to that. But the financial gain notion was pretty well destroyed when the witnesses came in and said that they knew there was no insurance policy because it was talked about at the office and it was talked about between Jose and Kitty Menendez, and Jose had all these reasons for not taking the physical. So that took care of that. And then Carlos Baralt testified. And Carlos Baralt gave the one piece of evidence that blew the financial theory out for all times. Jose Menendez told him that he had told his sons, not you're going to be disinherited if you don't shape up, which is how Mr. Kuriyama would have you hear it. What he told him was, you are out of the will. And Jose said he told that to Carlos. Jose said he told that to the boys before he was talking to Carlos Baralt, and he was talking to Carlos Baralt in June or July of 1989. So that pretty much put to rest the murder for money theory. So what was the next theory? The next theory, if I recall, was murder for hatred. And the problem with that is that not a single witness came into this courtroom, and I'm leaving Dr. Oziel completely aside for the moment, as a very special case. Not a single witness came into this courtroom who knew Erik Menendez and his parents, who said that Erik ever said a negative thing about either parent his entire life. And the same was true with respect to Big Brother. Not a single witness said that Lyle ever said a negative thing about his parents his entire life. Now, how many families do you know with 18 and 21-year-old children where the kids never complain, never say a negative thing about their parents? That is extremely unusual. But the fact is, there has been no evidence ever presented that Erik expressed any hatred towards his parents. And in my opinion, he had plenty of grounds for it. But based on what kind of person he had become, he didn't feel anger or hatred towards his parents. He idolized his father, and he felt sorry for his mother. So the hatred theory went nowhere. So now what is the theory of why these two young men killed their parents? Well, what I just heard was the Dr. Oziel theory. They killed their father because he was controlling them and dominating them, etc., etc. And so I understand at least where the prosecution is coming from now on the why Jose Menendez was killed, but I still haven't figured out what their theory is for why Mary Louise Menendez was killed. Surely, to quote my client, surely they don't believe that she was killed in the course of a mercy killing. Nobody could believe that. It is cuckoo. It is crazy. It is bizarre. It is the kind of thing that clearly you can wind up talking about if you spend too much time around L. Jerome Oziel. But short.
Overall, you may proceed.
I don't understand that, but okay.
Go ahead. Just
Thank
continue
you.
your argument.
This is the theory, the mercy killing theory that Dr. Oziel claims first came up on October 31st, that Erik testified was Dr. Oziel's idea, and that is again repeated on the December 11th day. Now, during the course of this trial, the prosecution was faced with overwhelming evidence of constant, chronic, high-level and low-level cruelty by these parents towards their children. It went on and on. And now Mr. Kuriyama tells you that he wants you to ignore all of it. The same was true about the evidence of the sexual molestation. It was extensive, it was severe, it went on for years and years, it took many forms, and he wants you to ignore that too. He says it's made up. I say, prove it. He says, ignore everything that happened before. And I am telling you that it is a jury's obligation to weigh the evidence, not the bias of the prosecutor, but the evidence that was properly presented to you. This was not a case, as I'm sure you all noticed, where evidence just went on and witnesses just talked and the other side was silent and there were no judicial rulings. Every single piece of evidence that came in was fought over. And the court was called upon, more so than in many other trials, to make a lot of evidentiary decisions. And he made them. The judge made them either from the bench or we all went over there and had our little powwows every few minutes, and sooner or later all these decisions were made and you heard the evidence come in and it was properly before you, because if it wasn't, the judge wouldn't have let you hear it. It's that simple. That's what his job is, to decide. And in deciding what evidence is proper.
Not only that, but there were so many people that corroborate the maltreatment of the kids from Jose and Kitty. So many people, so much evidence in this case, more so than most CA cases.
Properly before you is the overriding theory of what is relevant, what matters, what speaks to the issues in the case. And the defense in this case has always asserted that this horrible, ugly thing happened because those children lived in a horrible, ugly environment for years, in which they were terrified, in which Erik became an extraordinarily fearful and anxious child, so that when he reached an age and a place in his life where he could not take the worst of it anymore, and made some feeble effort to stop it by going to his, frankly, equally screwed up brother for help, this is what ultimately ensued. And what we wanted to do in presenting our evidence was make you understand why it was Erik reacted with such fear, why it was he believed that his parents were about to kill him, and why it was this happened the way it did. And so, how do you prove that? I mean, obviously, if I had a videotape of Jose Menendez performing a sex act on Erik, I would have put that on, and I wouldn't have needed all those other witnesses. But the crimes that were committed against Erik Menendez did not wind up in this case, and don't ever wind up with the police coming in and taking pictures. It's very easy to go to a crime scene of a homicide and to take all the gruesome pictures in the world and parade them later in front of a jury and get those people upset. But where is the picture of Jose Menendez bending Erik over the footboard of his bed when he's 12 years old so that his father can now go all the way in spite of the child's screams? Well, there is such a picture. But unfortunately, it only lives in Erik's mind now. And I doubt very much that Jose Menendez was very troubled by it during his lifetime. But I can't give you that picture. I can give you something very unusual to find in cases like this, which is some hard evidence of molestation. And hard evidence of molestation is very hard to come by because molesters are secret. They are sneaky. After all, they are exploiting weak little children. And they hide it because they know the rest of us don't think much of that.
Yep.
I'm going to leave these up here. And I'm going to leave them up here because ultimately you'll get over the trick that's being played on you and the shock value will diminish. So that when you go back into the jury room to decide this case, you're not going to decide it because you're still upset over those photographs. And I'm not going to leave my photographs up here because I'm not trying to shock you. Now this is a copy of the photograph that's in the exhibit, but this is only a copy of it. And I'll show you why I'm putting a copy up. Now this is the crime of Erik Menendez. And I cannot show you the crime that Jose Menendez committed on him, but you heard about some of the things that he liked to do to his little boy. And one of them was to stick tacks like this in his thighs and in his butt, and to run needles across his penis. Now that's this man. And I don't recall if there are autopsy photographs of this man where you can see his penis, the one that he stuck in this body, that Mr. Kuriyama tells you is all made up. The proof that it isn't all made up is who Erik wound up being. And I put Dr. Vickery on the stand to tell you how sick this kid got behind the home life that these two very dead people provided him with. Now there's one thing that Mr. Kuriyama, I want you to look very carefully at this proof sheet. This is a proof sheet of the sequence of the photographs from Erik's 6th birthday party. These photographs were found in this envelope. This envelope has the handwriting of his mother, Mary Louise Menendez, and she had a beautiful handwriting. She was a school teacher. And she wrote Erik's birthday, November 1976. And inside this envelope were the original small prints taken on that roll, from which this is an enlargement. And also inside that envelope were the original negatives. And so what we did was we had blow-ups made from the original negatives. And we had a proof sheet made of the order of the photographs on the roll, so we could see which was taken first, which was taken second. Now I happen to know, for reasons I cannot reveal to you, what the prosecution's theory is about this photograph and the one of Lyle, which I will also show you. This is the one of Lyle's nakedness, which was saved by his mother, kept in that envelope. Now, both from the cross-examination of Erik, I suppose, was the first clue, that the prosecution's theory is that the boys, the children, took the naked pictures. And somehow that theory, I think, has to do with some kind of visual perspective that they want you to speculate about based on the height of the person who took the picture. Now, that's wonderful, except people who take pictures can bend down and take pictures of little children's genitals, even if they're big people, even if they're grown-ups. But frankly, there is absolute hard proof that Erik Menendez did not take this nasty picture of his brother. And here's the proof. If I haven't misplaced it, okay? Here it is. The proof sheet is the proof. The sequence of the photographs. Here's a gathering of people. Here's Lyle in the bathtub, one can assume the morning of the birthday party. And here is Erik in bed. Now, Erik is in bed when this naked picture of Lyle is being taken. See, here's the next picture on the roll. Now, are we supposed to believe that 6-year-old Erik, who testified he was not allowed to handle a camera until he was 12 or 13, got out of bed to go take a naked picture of his brother, and they got back into bed so someone could take a picture waking him up? And it isn't until way down here on the roll that the naked picture of Erik shows up, and then a picture of Mrs. Menendez's favorite thing, her animal, Tristesse. And I think it's really amazing if you could go back and remember the testimony, for example, of Terry Baralt, who was Jose's sister. She was asked about Mary Louise Menendez and who was it or what was it that Mary Louise Menendez showed affection for. And when she started talking about the animals, you could see the animation even in Mrs. Baralt's face. Oh, Kitty loved her animals. She showed them all sorts of affection. She took such good care of them. She never showed anything like that to her children. But here's a picture of her favorite little dog, Tristesse, next to her naked child. I promised I wouldn't leave them up, and I won't. I'm going to talk later about all of the evidence that corroborates the sexual molestation of these boys in this case. I keep promising what I'm going to do later. But you can't do everything at once. I will say this about the molestation evidence right now, and that is this. We presented this evidence to the testimony of Erik Menendez, and Mr. Kuriyama refused to ask him a single question about it. He ran from this evidence. Because he knew if he questioned Erik, if he used the tool that you're supposed to use to question a witness, which is cross-examination, which he does rather well, I mean, he cross-examined Erik about the crime scene ad nauseum. He questioned him about what they did after for a day and a half. He knows how to ask questions, and he is a very aggressive cross-examiner. He argues a lot. He insinuates. He's quite sarcastic and snide. He's got all the tools of the trade, and he used them. And he just spoke to you about how successful he was using those tools. Now, I will dispute some of the things he said about how successful he was, but it is true. The purpose of cross-examination is to try to show when a witness is not telling the truth or is mistaken in their testimony, and Mr. Kuriyama does it rather well. But he didn't ask a single question about the molestation. Why? Because he was afraid that he would not be able to show that it wasn't true. And he didn't want you to hear it. He wanted you to hear about the shooting. He wants you to see bloody photographs over and over. But he didn't want you to hear Erik Menendez talking about these hideous things again. He hoped perhaps you'd forget about it somehow, that it would leave your consciousness if he didn't cross-examine about it. They put Dr. Oziel on the witness stand, who said dreadful things, horrible things, things that if you believe they're true, yes, they're guilty of first-degree murder. That's what Dr. Oziel was. He was the entire centerpiece of their case. He is the only witness who could give you first-degree murder. It rises or falls with him. There's nothing else. And they put him up here, and he said these dreadful things, and we cross-examined him on everything he said they said. We cross-examined him on everything he said he did, all his reasons, all his motives, what happened in the session, how were they conducted. We didn't run from that evidence. And we were also able, not just by cross-examining him and showing what sort of witness he was, we were able to show what sort of person he was, both through the way he testified, the things he said, and the other people that we put on to talk about him. And that's what you do. If this is really a search for truth, you cross-examine witnesses and you test what they're saying to see if it's true. And they ask nothing about the molestation, and therefore it is totally uncontradicted evidence. Nobody came in here and said Jose Menendez didn't or couldn't have molested his kids. Nobody came in here and said Erik told me the molestation was a fantasy. It's completely uncontroverted. Now, it wasn't put on for you to say, oh, these people are monsters. They did dreadful things. They deserve to die. We never called Jose or Mary Louise Menendez monsters. Their children never said a negative word about them in life, and they didn't say a negative word about them in death. They didn't say they were terrible people, they were bad people. All they did was tell you what it was like living with them. What were the things that were done to them? How did they accommodate themselves to it? And how did they feel about themselves and about life as a result of having been raised by them? They didn't get up here and call their parents names, and neither did anybody else that we called. They described these people. They talked about their personalities. They talked about their character. They talked about how they raised their kids, but they didn't call them names. They didn't call them vicious beasts or monsters. And they weren't monsters. They were people. They were people who did some dreadful things to their children, but they were people. And Erik is a person, not a vicious brat, not a cold-blooded killer. He's a person. And in order for you to decide why he did what he did, you have to decide what kind of person is he. And after lunch, I have some charts I'm going to show you to help remind you of who it is he was before Mr. Kuriyama got his hands on him to characterize him in his totally fantastic way. Now, the other way to challenge evidence, such as the molestation evidence in this case, is to call your own expert witnesses to say, that is a made-up story. It doesn't fit the research. It doesn't fit the way other kids talk about it. I don't believe him. He didn't have the right demeanor when we spoke. He didn't give the right kind of details. There's a lot of research, as you learned, going on in the field of child sexual abuse and other forms of child abuse. There are people conducting studies all over the country. We called expert witnesses. First of all, frankly, to tell you that he was telling the truth, that in their opinion, and they were qualified, internationally respected experts, that in their opinion, he was molested. That's why we called them, to overcome what we knew would be the prosecution saying, it didn't happen. Why didn't it happen? Because Mr. Kuriyama doesn't want you to think it happened. He doesn't want you to believe it. And a lot of people have a hard time believing that these things happen. That's been the tragedy in this country with child abuse for so long. You don't want to believe people do this to their kids. You wouldn't do this to your kids. And you wouldn't want anybody you know to do this to your kids. And you don't want to believe it happens. And there's a lot of resistance to it. And there's a lot of resistance because we don't respect children very much in this country, in spite of all the lip service that we give to child issues. We think children lie. We think children make things up. We think children fantasize. So when children are victims, we scrutinize them differently than we do adults. So they have a hard time, these children, convincing the grown-up world that bad things are happening to them. And so we brought in these experts to validate, flat out, what he was saying. Now, you don't have to believe him just because the experts do. Clearly you don't. You are the judges of the facts. You have to decide, did it happen on your own. And not because Dr. Burgess, who works with the FBI, even though she's got terrific law enforcement credentials, has worked with law enforcement for years and years, cannot be called a defense-biased witness. Even if she believes him, you don't have to believe him. Even if Dr. Vickery comes in here and tells you what kind of person Erik really is, you don't have to believe him either, because you get to decide the facts. But we brought you these people so you'd have some help in making that decision. And beyond that, we brought in the experts on abuse so that you would understand why it is that abused kids see the world differently than you or I. And therefore, why it is that abused kids could honestly believe that their parents were going to kill them, and take this action motivated by fear when, in fact, as they found out, and we all know, their parents at that moment at least were not about to kill him. They were wrong. But the issue is, could they have honestly believed that based on what happened that week, viewed through the prism of their entire previous life? Because if you or I or any of us, the non-abused children, hopefully, I don't know that much about their backgrounds, the non-abused children, at least not this kind of abuse, in this courtroom, walked in to that house on Elm Drive at approximately 10 o'clock on August 20th and had had the same interchange with Jose and Mary Louise Menendez that Erik and Lyle did, none of us would have thought, oh my God, they're about to kill me. We just wouldn't have. Because we wouldn't have had the knowledge, of the special knowledge, as it's called, of the prior threats, of their hostile and aggressive behavior to us. We wouldn't be in fear of them. We're big people, and they're not our parents, so they don't have that kind of power over us. We wouldn't understand the significance of the gestures or the significance of the words. It would mean nothing to us. And so as reasonable and reasonably normal, I hope, people in that foyer that night, none of this would have had meaning to us. But the issue for you is, did it have meaning for Erik and Lyle Menendez? And based on their history and based on what happens to severely abused kids and how they respond to threats and fear, could it be said that they had an honest and actual belief that their parents were about to kill them? And the reason that is the question is because that is the defense in this case. And Your Honor, this is a good time to stop that.
We'll be in recess until 1:30. Don't discuss the matter with anyone. Don't form any final opinions about the case, and we'll resume promptly at 1:30.
Which talked about not being influenced by sentiment or sympathy. And I want to make something very clear here. We did not put on all the evidence of all the things that were done to Erik in order to evoke sympathy. If that's all we wanted to do with that evidence, if that's all we thought it was relevant for, we would wait and see if there were a penalty trial in this case when such evidence is often presented and presented then. The purpose of that evidence was to show you what state of mind he was in on the night of August 20th and how all of his life experiences led up to the condition that he was in that night. And so that was the actual purpose for it. But we have an affirmative reason why we do not want you to decide this case based on sympathy for him or prejudice against him. And it really has to do with a philosophical issue. And that issue is that abused children in this country do not want pity for what they have been through. And Erik doesn't want pity for what he has been through. Pity isn't really what's going to solve this problem. What he wants is understanding. And the reason we put that evidence on is in the hopes that you will understand what happens to a child, how they do not develop normally, what happens to their view of themselves and their view of the world, and how they can then be set on this collision course with violence that the Menendez brothers were set on. We want your understanding, and we want you to apply the law. Now, the law that I'm going to talk to you about, and I have to do it now because the rest of my argument won't make sense. I'm not going to do it all at once because it's really tedious, but I'm going to do some of it. The law is a little behind psychology, if you will, and that's sort of typical in our society. It takes a while before new knowledge is totally absorbed into the law. When we started this case, if you remember the opening statement that I gave, I talked to you about self-defense. Now, what I didn't tell you then and what we didn't tell you in the juror questionnaires, because there's no purpose in making things too complicated, is that in the state of California there are two different kinds of self-defense. One of them is what is called complete or perfect self-defense. And perfect self-defense is something that you had some questions about, that we asked you about on the juror questionnaire. And it has to do with a person who has a good faith and a reasonable belief that they need to use deadly force to defend themselves against imminent peril to their life, or the imminent threat of great bodily injury, or the imminent threat of the commission of what we call in the law, in our very ungrammatical English, a forcible and atrocious crime. And if someone acts in perfect self-defense, and if a jury finds that they acted with a good faith and a reasonable belief in the contingency of peril, that person is not guilty of any crime at all. That is justifiable homicide. Now, when we started this case, we did not know all of how the evidence would come out, and we did not know what the legal rulings in this case would be. And as a consequence, you are not going to be instructed on perfect self-defense, which could lead to a finding of justifiable homicide. And that is a matter of some disappointment to me, but my disappointment isn't all that relevant. You are nevertheless going to be given a verdict form that allows you to vote not guilty. And that is a constitutional issue. No jury can ever be told they must convict. Every jury has the option of acquitting. However, I do not have the option of arguing the theory of perfect self-defense to you in order to bring about that acquittal, because you're not being given that instruction. You are, however, going to be given the instruction on what's known as imperfect self-defense. And the difference in imperfect self-defense is that is when a person has an honest and good faith belief that is not reasonable, that is unreasonable, in the need to defend themselves against imminent peril to life, or imminent threat of great bodily injury, or imminent threat of the commission of a forcible and atrocious crime. And what that means is if someone is truly in fear, actual fear, that they're about to be killed, or they're about to suffer great bodily injury, or they're about to, for example, in our case, be raped, that person, if they act to defend themselves, can be convicted of no more than manslaughter. And I have, in order to tell you about that instruction and that rule, I want to start with the instruction that Mr. Kuriyama already showed you about murder. My client is charged in 2 counts with murder, and the people are asking you to make a finding that it is first-degree murder. And later on, if I feel like it, frankly. Later on, if it seems to fit in the argument, I'll go back and describe the difference to you of what second-degree murder is versus first-degree murder. But I can tell you now very plainly, I am going to be arguing in this case that if you must convict, that you convict for no more than manslaughter. And later on, I will get into the death. There's two kinds of murder that you'll be instructed on, first degree and second degree. There's two kinds of manslaughter you'll be instructed on, voluntary and involuntary. And I will go through in more detail a little later all of the distinctions between those four. But in order for you to understand the rest of my argument having to do with why Erik felt fear, you need to know where that goes, ultimately, in your decision-making process. So, the definition of murder has three elements to be proven. That a human being was killed, there's no dispute about that. That the killing was unlawful, and for reasons I'll show you in a minute, there's really no dispute about that, given the instructions you're going to be given. And that the killing was done with malice aforethought. Now that's the key here as to whether a killing on, I told you about justifiable homicide, that's a lawful killing. If you act in perfect self-defense, it's a lawful killing. If you act in imperfect self-defense, it is an unlawful killing, but it is not murder. So you can have an unlawful killing that is a manslaughter, that is not murder. And the difference between murder and manslaughter is this very peculiar concept called malice aforethought. As Mr. Kuriyama read to you, malice doesn't mean in the law what we feel it means in ordinary language. It doesn't mean hatred. It doesn't mean any particular negative emotion. If I have to put it in layman's language, the only way that I can understand it is a negative way. Malice means, pardon my French, without a damn good reason. If you have a damn good reason, a reason that the law accepts for doing your unlawful killing, then malice is not present. And in fact, it's really a recognition, if you will, in the law. The criminal law is really a sort of law that combines morality and psychology. And the morality part is a judgment. And the judgment is if you are acting out of fear and you're acting in good faith and you believe you're defending yourself, you're just not as culpable and you shouldn't be held to as severe a crime as if you're acting just for the fun of it, for no damn good reason, which is what malice is. By the same token, to complicate your life more, there's another way in which you can analyze situations in which people commit unlawful killings that are not murder. Another way beside imperfect self-defense, and that is called provocation, heat of passion. And that is commonly what happens, for example, if two people in a bar are in whatever condition. Let's assume they're sober because that eliminates other complexities. And one of the people in the bar calls the other a racial epithet, for example. Now, those are known as fighting words in the law. And if you insult someone that way, and as a normal person, they take offense and get very excited and worked up, and if they take action against you, that can be considered sufficient provocation so that when they take action against you, it isn't murder. And there are definitions you'll get of what emotions constitute sufficient provocation. Strangely enough, one of those emotions is fear. So there's actually two paths to wind up with manslaughter in this case, the imperfect self-defense, and under the notion of sudden provocation, heat of passion, is this concept. Let us assume for a moment that in this particular case, Erik had not gone to Lyle and talked about his molestation. Lyle had not gone to Jose Menendez and had that talk that led to the death threats. And the fear of death was not the rising level of fear over the next few days. Let's assume a different scenario. Let's assume that Jose Menendez told Erik outright, I'm going to continue having sex with you because you are my toy and my plaything. You are my throwaway son. I really don't care how you feel. And it's going to go on. Words. And at that point, Erik killed his father. Now that is a classic situation of sufficient provocation, heat of passion, okay? Without this other component of self-defense. And in this case, I will argue to you later, there is another way of analyzing what happened in this family as a provocation, heat of passion episode rather than as a fear of death, self-defense episode. It really doesn't matter which one you decide makes more sense to you. And it really doesn't matter if all of you decide on the same theory of manslaughter. Some of you could actually believe that this fits sudden provocation, heat of passion, and the others could decide it fits imperfect self-defense, and you'd get to the same result, and that would be perfectly legitimate. But for now, if I know where Miss Morrissey put the charts. Right there, right here. Okay. Now, I'm not sure which, I think I'm going to put them here because this is more stable on the tripod. Problem is I can't read it. And as I just told you, this is an instruction you're going to get. Sorry they're not printed, Doctor. I didn't do it. Okay, and what this instruction tells you is that the distinction between murder and manslaughter is that murder requires malice, while manslaughter does not. When the act causing death, though unlawful, is done in the heat of passion, or is excited by a sudden quarrel, such as amounts to adequate provocation, or, and here's where we get to the imperfect self-defense part, in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury, the offense is manslaughter. In such a case, even if an intentional intent to kill exists, the law is that malice, which is an essential element of murder, is absent. In a way, the easiest way to, if you want to get real analytical about this, the easiest way to look at it is that these two emotional states, heat of passion or good faith but unreasonable belief, just erases malice, just counteracts it. And that's the simplest way, I think, of analyzing the instructions, because if you try to figure out what is malice and is it there, you're going to go crazy, because the instructions don't really tell you what malice is. For example, the instruction with respect to express malice basically tells you express malice is intent to kill. And that can be confusing, because voluntary manslaughter, a crime where there is no malice, also has intent to kill. The difference is, though, that if it's intent to kill in a voluntary manslaughter setting, if it has one of these two emotional states, the malice of murder has been erased, and that's about the only way to make sense of this. Now, to establish that a killing is murder and not manslaughter, the burden is on the people to prove beyond a reasonable doubt each of the elements of murder, and that the act which caused the death was not done in this heat of passion, or the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury. And I want to focus on that for one moment here, because I think this is something you've all heard about, the burden of proof beyond a reasonable doubt. We put it in the juror questionnaires. None of you believe the innocent should have to prove themselves innocent, or a defendant should have to prove himself innocent. If you thought that, you wouldn't be here. And all of you seem to understand that concept of reasonable doubt. But what juries don't always understand is that if you really think about what that means, what it means is basically the prosecution has to prove us wrong beyond a reasonable doubt, because we clearly have presented evidence to show that Erik's state of mind on the night of the shooting fit one or both of these categories. And therefore, for them to win, and for you to come in with a murder conviction rather than a manslaughter, they have to prove that we are wrong beyond a reasonable doubt. Because they have to prove that murder is true and manslaughter is not true beyond a reasonable doubt. They have to prove every element of murder beyond a reasonable doubt. And if we have raised through our evidence a reasonable doubt that malice was present, a reasonable doubt as to whether or not they were acting in heat of passion, or whether or not they were acting in fear, they lose, we win. And it can be no more than manslaughter. And you will see throughout the instructions that the burden is always on the people to prove beyond a reasonable doubt the crime that they are asking you for. And if they can't do that, you are compelled by law to find the lesser crime.
I just want to pause there and say, do you see why this is like this part is important regarding manslaughter versus the M charge? Because now, as we're looking at this case, the jury that actually did convict them didn't get to see all of the stuff about the CA and SA because Judge Weisberg, the same judge, didn't let it in. He ruled in favor of I'm sure there was probably like a motion in limine or something, and it was determined by the judge that it should not come in, which was a huge mistake in my part, or in my opinion, on his part. So this whole manslaughter versus, if they would have been convicted by this jury, it was pretty much split basically. So they had obviously it was a mistrial. It was a hung jury. They couldn't all decide, but I think it was more, the females were more in favor of either giving them the manslaughter charge or the even lesser charges where it was like imperfect self-defense. However, the men in this case, many of them wanted to give them the full extent of the law. So that's why they were hung. But it's important because in this case, when we know all of the facts and we know all of the abuse that was going on in the house, manslaughter is the appropriate charge here. And that means they should have been released about 11 years ago, give or take. So.
I was just talking about reasonable doubt. I'll put it up. Again, it's the way these legal concepts are framed is so alien to ordinary speech. It's very hard for people to really understand the meanings. And I'll read this to you, and then I'll tell you what I really think how reasonable doubt operates for jurors versus the definition. Here's the definition. A defendant in a criminal action is presumed to be innocent until the contrary is proved. And in case of a reasonable doubt, whether his guilt is satisfactorily shown, he is entitled to a verdict of not guilty. This presumption places upon the people the burden of proving his guilt beyond a reasonable doubt. Now, as I just told you, and you'll see it in some of the other instructions, that in case of a reasonable doubt whether his guilt of a particular crime is shown, he is entitled to a verdict of not guilty for that crime. For example, you're going to get the verdict forms here. There's only one not guilty verdict form. We didn't do separate ones for each crime. So let's say you get together and in your deliberations you decide, no, there is no evidence, there is not evidence beyond a reasonable doubt that he's guilty of first-degree murder. You won't have a first-degree murder not guilty form to sign at that point, but in your head you will have made that decision. He's not guilty of first-degree murder, let's look at second-degree murder. And again, if you look at second-degree murder and you say, no, I still don't see malice because of this defense evidence, you won't have a verdict form at that point that says not guilty of second-degree murder. That's just a decision that you have made and discussed, and I assume votes that you've taken. So then you get down to the next level, which is voluntary manslaughter. And you look at the definition of that and you weigh the evidence and you may say, no, I don't think they have proven beyond a reasonable doubt that he intended to kill. And therefore, he's not guilty of voluntary manslaughter. And you won't have a verdict form that says not guilty for that either. That's the decision, that's your agreement. And then you get down to involuntary manslaughter, and you decide, yes, have they proven involuntary manslaughter beyond a reasonable doubt? And if you don't believe that, then you get to sign the not guilty verdict form. But at every level, the people have to prove all the necessary elements beyond a reasonable doubt. And to do that, you have to decide what the facts are. Did they prove the facts beyond a reasonable doubt that are necessary to come in with the conviction that they want? Or did the defense prove facts that make me doubt that they have done that they have proven murder, or that they have proven intent to kill? Now, this is the part of this instruction that always makes me sort of smile, because it's pretending to define for you what reasonable doubt is, but I don't know that anybody ever really gets it. Reasonable doubt is, and it has nothing to do with intelligence, it has to do with we don't think this way most of the time. Reasonable doubt is defined as follows. It is not a mere possible doubt, because everything relating to human affairs and depending on moral evidence is open to some possible or imaginary doubt. Now, you can hypothesize what that means. Pigs can fly, for example. I guess that's possible. I've never seen it, but I can imagine it. But it really does mean something like that. Anything is possible. Spaceships could land on the courthouse. It is that state of the case which after, and I had a client once who really thought spaceships were landing on the courthouse. So, it is that state of the case which after the entire comparison and consideration of all the evidence leaves the minds of the jurors in that condition that they cannot say they feel an abiding conviction to a moral certainty of the truth of the charge. Makes perfect sense, right? Okay, I guess what it means, though, it's an issue of conscience. I think what it means, and I think how jurors decide it, is this. Look, this is serious business being a juror in a criminal case. What I decide has enormous consequences for any case. I mean, being a convicted criminal for a citizen is a big thing, no matter what the crime. Certainly this is the most serious of all kinds of cases. But the standard's the same whether we're talking about drunk driving or murder, strangely enough, because the notion is anytime someone's convicted of a crime, the state then has power over them for punishment purposes. And so every single time, jurors have to feel confident that their verdict is correct. And this is a way of trying to tell you what your internal process should be that makes you feel confident. An abiding conviction, something you really believe in and can hold on to even a week after the case is over, and 2 weeks later, and a year from now, and 10 years from now. And to a moral certainty, I don't really know what that means except that you are morally comfortable with your decision, that you're never going to second guess yourself and worry and wonder. And another way that people have talked about this is having the same confidence in your decision as you would have in the most important decisions in your life. Now, I'm not sure what those are. We used to talk about it being in terms of the person you marry, but this is California, given the divorce rates, who has confidence in that decision anymore?
All right, ladies and gentlemen, I am going to instruct you on the law at the end of the trial. Counsel at this point during their argument are just referring to certain legal principles. I'll give you all the legal definitions at the end of the trial. And another reminder, when counsel comment on the evidence, whichever lawyer it is, again, they are just commenting on the evidence. You are the ones who evaluate the evidence inside the evidence in this case, and they're just commenting on it at this point. All right, you may proceed.
Thank you, Your Honor. In any event,
Why the hell did they need that instruction right now? I think that was improper. I think this judge sucks.
the notion is it's an important decision and you have to decide it with that level of commitment and seriousness. Now, this is the definition I was telling you before, which you will receive this instruction. This is imperfect, so-called imperfect self-defense. A person who kills another person in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury, or the commission of a forcible and atrocious crime, kills unlawfully but does not harbor malice aforethought and is not guilty of murder. This would be so even though a reasonable person, that's like one of us, in the same situation, seeing and knowing the same facts, would not have had the same belief that it was necessary to defend. Such an honest but unreasonable belief is not a defense to the crime of voluntary or involuntary manslaughter. And what that means is, as I told you before, it is unlawful to kill in an honest but unreasonable belief, but it isn't murder. And so it's not a defense to the non-murder unlawful killing, which is manslaughter. Forcible sodomy is a forcible and atrocious crime, so that if you kill to prevent someone from doing that to you, you fit within this definition. Now, I just want to point one thing out to you, and this is that the unreasonableness of the belief can apply to all of the considerations here. In other words, you can be unreasonable in your belief that it's necessary for you to defend at that moment rather than do something else, say, like flee. You can be unreasonable in your belief that the peril that you're concerned about is actually life-threatening rather than some lesser form of harm to you. And you can be unreasonable in your belief that the peril is imminent, that it's going to happen instantaneously rather than a little bit later. So in all those ways you can be unreasonable, but if you are honest, if you have this true conviction, this true belief, then you can't be convicted of more than manslaughter. And finally, my favorite instruction here is involuntary manslaughter. And here's how it fits in, this concept of involuntary manslaughter, into the other instructions in this case. Every person who unlawfully kills a human being without malice aforethought and without an intent to kill is guilty of the crime of involuntary manslaughter in violation of Penal Code Section 192B. That's the section that defines manslaughter. In order to prove such crime, each of the following elements must be proved. Number one, a human being was killed, and number two, the killing was unlawful. And so you can see it's the first two elements, but missing the critical third element for murder. A killing is unlawful within the meaning of this instruction if it occurred in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury. So this is defining the imperfect self-defense form of unlawful killing that is nevertheless manslaughter. And the only difference between voluntary and involuntary with respect to definition is, one, they have to prove beyond a reasonable doubt an intent to kill. That's for voluntary. And if they fail to prove an intent to kill beyond a reasonable doubt, then it is involuntary manslaughter. Now, the other method of getting to manslaughter, the sufficient provocation, heat of passion, also leads to both voluntary and involuntary. And there are other instructions that tell you that. There. That wasn't so bad. Now we can move on. And we move on to one that I could show you the part of the instruction, but I think I'll just read it. I also have a copy of all the instructions you're going to get here. And this one has to do with a concept you've all heard about, but probably have not ever gotten a legal instruction on before. And it's called circumstantial evidence. Circumstantial evidence basically, and I'm not going to try to define it specifically because it's a long, complicated instruction, and you are to be guided by the instruction. But let me give you some simple differences. If I see one of you, for example, take the pencil of another juror, and I testify, I saw juror X take juror Y's pencil, that is direct evidence that juror X took the pencil. It's direct because it was witnessed directly, okay? By the same token, if juror X says, I took juror Y's pencil, his statement to that effect is also direct evidence that juror X took juror Y's pencil. But if instead of that, we have two jurors alone in the jury room, and juror Y puts her pencil down on the table and leaves, and juror X is left there alone, and 10 minutes later juror Y comes back, and the pencil is missing, that is circumstantial evidence that juror X took the pencil, because it was not directly observed, and it was not admitted, okay? So circumstantial evidence is evidence, as we define it, that leads to an inference, and that inference leads to establishing the ultimate fact. The ultimate fact in my hypothetical is X took the pencil. The inference in the second example I gave you is since there's no one else in the room, and Y left the pencil, and the pencil's missing, X must have taken it. That kind of thinking requires an inference. Now, many, many items of evidence that are presented in a case can raise different inferences. The same piece of evidence, and you've already heard some differences of opinion both throughout the trial, and you're about to hear a whole bunch of them. Differences of opinion and what things mean. Here's the fact. What does it mean? Because some facts are being used to prove an ultimate issue. For example, there's lots of things here that the prosecution at various times, either through Dr. Oziel or in cross-examining experts, claim is evidence that there was a pre-existing plan to kill. That's been a big component of their case from the very beginning. But the evidence they're talking about is circumstantial evidence. And I'm going to analyze some of it. But just to focus on the simplest example is the fact that guns were bought in advance. That's a big piece of circumstantial evidence in the prosecution's theory that there is a plan. But it is circumstantial evidence. And because of that, it's subject to inferences. It doesn't directly prove there's a plan. I mean, it's only the purchase of guns. It's not the writing out of a plan. So you have to make certain logical inferences from it. And the rule of law is, if an item of evidence, a fact like that, is subject to two or more reasonable interpretations, and one of those reasonable interpretations points to innocence, in other words, points to proving a fact that helps the defendant, and the other reasonable inference points to guilt, or points to help to proving a fact that helps the prosecution, because the burden of proof is on the prosecution, because reasonable doubt is the standard, you must find that interpretation which points to innocence. That's the circumstantial evidence rule. And now I'm going to read it to you so that you see how it works in the law. However, a finding of guilt as to any crime may not be based on circumstantial evidence unless the proved circumstances, that's the facts, are not only consistent with the theory that the defendant is guilty of the crime, but cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which such inference necessarily rests must be proved beyond a reasonable doubt. It's not simple, but it's easier if you read it, in fact. And I think you're going to have a set of instructions in the jury room, so you'll be able to read them. Also, if the circumstantial evidence is susceptible of two reasonable interpretations, one of which points to the defendant's guilt and the other to his innocence, you must adopt that interpretation which points to the defendant's innocence and reject that interpretation which points to his guilt. Now, there is a savings clause here, though. If, on the other hand, one interpretation of such evidence appears to you to be reasonable, and the other interpretation is unreasonable, you must accept the reasonable interpretation and reject the unreasonable. And when they're talking in this instruction about reasonable and unreasonable interpretations, they're talking about your analysis of the evidence, not what the defendant's interpretation of things was. Okay, so I don't want you to confuse this notion, how you evaluate circumstantial evidence, with the other notion of a good faith but unreasonable belief. This has nothing to do with that. Okay, that's all we're going to do with that instruction for the moment. Now, I want to return for a moment to my analysis, if you will, or my puzzlement, if you will, about what the prosecution's theory of the case is at the moment. As I said to you, it originally started out as some notion of a killing for money. Now, you understand, because you've been here and you've heard all the evidence that they have on this point, that what's always been peculiar, as I think I told you in the opening statement, about their notion of killing for money, is that they never had one shred of evidence that before the crimes, Erik ever expressed any need for money, any interest in getting money, any desire to kill his parents for money, any complaints about his financial situation. And that is very typical evidence in a case where they're asserting that it's a killing for money. And I can think of a situation, perhaps, an extreme case, where a kid could kill a parent for money. And here's what it would be, and it does happen. There are some people, children, who get very strung out on drugs and who get very involved with very bad crowds, okay? And I can see situations where someone who has been involved with drugs, involved with gangs, involved in criminal activity, who could get to that point where they could consider killing a parent for money. But there's anything like that going on here. So for them to simply assert that the killing was based on money has to do with a certain kind of prejudice, a certain kind of discrimination, if you will, that has been going on in this case from the very beginning. And it's something Americans sort of like to do, but it's called hate the rich. And this notion of discrimination has filtered through the whole case, even in the attitudes that both prosecutors showed towards both defendants when they were on the witness stand. It's one thing to be hostile to a witness who you know you can show is an incompetent and unethical and lying person. It's another thing just to be nasty because you're either the defendant or you're a defense expert, or because the prosecutor wants to convey the image that you're a snotty rich kid, even if you never act like a snotty rich kid. So this notion here that somehow, because the family had money, that is a negative quality of Erik and of his brother, has managed to go through this trial when if they were making the same kind of discriminatory, if they were displaying the same discriminatory attitude towards these defendants because they were, say, Chicano, or black, or Jewish, or Muslim, or any other category of person, it would be unthinkable. It would be outrageous, and everyone would be offended. But they've been allowed to raise this inference over and over again that there's something basically bad about the boys because their parents had money. And the sad thing about that is that the fact that their parents had money made their lives worse because it gave the parents more control and more isolation, more insulation, if you will, from the probing eye of other people who might care. It also made them look successful. And we have this weird dichotomy in our culture, I believe. On the one hand, we hate the rich, and on the other hand, we all want to be them. So we both admire them for their money and are sort of in awe of them, and on the other hand, resent them. And the resentment here is falling on the heads of the two brothers. Now, you have to ask yourself, is there any reason why, given the nature of family relationships, how children are connected to parents, how dependent they are, how they're born wanting to love their parents, how parents can limit their universe and limit their vision and keep them very focused on the family, is there any reason to believe that the children of the rich love their parents or are linked to their parents or are bonded to their parents to any less degree than the children of the poor? And so you say to yourself, I hope, what would the prosecution be saying in this case? With no evidence whatsoever of a pre-existing need or desire for money, what would they be saying in this case if the Menendezes were poor? They killed them for something else. And of course, they had slid to the something else theory too, because they were unable to prove that the killing here was for money. Not only because there was no pre-existing evidence of it, but because we were able to show that Erik and Lyle knew they were disinherited. Their father had told them. We were able to show they knew that if they had just waited a few weeks, there would have been that $5 million policy. And if money was their issue, they would have waited. If any plan was their issue, they would have waited 2 weeks to get handguns. And we'll get back to that in a minute. But all of this notion of money links up with this notion of plan, and plan is what they need to get you to convict of first-degree murder. Without plan, there is no murder in this case. Okay. One point I wanted to make about their supposed money evidence. Mr. Kuriyama misstated the import of Roger Smith's testimony. Roger Smith testified that when he says at the meeting on Tuesday at Live Entertainment that there is no $5 million policy, that nobody is surprised. That the impression he gets is that clearly the family, which was Erik and Lyle and Uncle Carlos and I think Uncle Brian, knew that there was no $5 million policy because they didn't react. They showed no surprise. And Carlos testified, Carlos Barral, that he knew before that meeting that Jose had talked about the fact that he hadn't taken the physical and that at the very least Maria Menendez, Jose's mother, and Lyle knew that he hadn't taken the physical and therefore didn't have the policy before he died. So the importance of Roger Smith in that aspect of his testimony was to corroborate both Erik and Lyle. So that it isn't just their word telling you that they knew there was no such policy. And Mr. Smith told you that he had had conversations with Jose Menendez around the office, that Jose was being pressed by Rod Tovinger, who I believe was the controller of the business, to take the physical and so that he could get this provision in his contract, and he kept putting it off and stalling. And we have wondered for 3.5 years, as trying to read the minds of Jose and Mary Louise Menendez, why it was that Jose did not take that physical. And there were two possible explanations, I think, based on the evidence. One is that he had had this heart attack, or some kind of angina problem. It wasn't a full-blown heart attack, in January of 1989. That's why he didn't take that trip to Amsterdam that Roger Smith went on. And he may at that point have been afraid of taking the physical because he wouldn't pass it. But there's also another theory, and that theory is that Jose Menendez was talking about, seriously talking about, how Mary Louise Menendez appeared to want to poison the family. You may remember the testimony of a young woman excuse me, named Tracy Baker. Tracy Baker, who was a friend of Lyle Menendez's for a very brief period, like a month, who went over to their house sometime in November of 1988, who was asked to stay for dinner, and then something really weird happened. And what happened was Mrs. Menendez brought out the food. Mr. Menendez looked at the food. "What are you trying to serve me? What's in this?" he said, and ordered the boys and Miss Baker out of the dining room, left the house, went out to eat. Now, he seemed suspicious of what was in the food. He was acting as if he believed she had put something in there. Now, both Erik and Lyle testified that their mother had threatened that she would poison everyone in the family, and they both testified that their father seemed to take these threats very seriously, and that there were a number of times when he'd get up from the dinner table because he suspected that the food was poisoned. Now, what's interesting about that from our perspective, from the perspective of how did this impact Erik Menendez's perception of his mother and whether she was a scary and dangerous person? And that's this. I don't know if she was really trying to poison the family, and I don't know if Jose even thought she was, because if you remember, he had this wicked sense of humor. He liked playing practical jokes. One of our witnesses, and I think it was Carlos Barral, but I'm not sure, or Terry Barral, said that Jose thought it was very funny, for example, in a social setting or at a party, to tell people that someone else that they knew at the party, for example, his wife, had cancer, and then everyone would treat her peculiarly. And he thought that was amusing. And I wouldn't doubt that he would think it amusing and a way of keeping everyone in the family alienated from each other, because divide and conquer certainly was his way of running this household, and keeping the boys afraid of their mother and the mother excluded from liaison with the boys by pretending that he thought she was poisoning the food. I don't know which it is, but what I do know is that from the perspective of Erik and Lyle, they're seeing their incredibly powerful, strong father refusing to eat in that house under the guise that mom's trying to kill us all, and that makes mom dangerous to them. Now, the other component of this greed theory, and I guess I'm talking about, I think it's been completely discredited, but it so offends me that I want to continue to talk about it for another few minutes. And that's the notion that they killed their parents. Erik killed his mother and his father because he wanted to buy a Jeep. That's the basic notion. Or he wanted to buy a Jeep and a pool table. Or he wanted to buy a Jeep and a pool table and some furniture, because that's what he bought. Now, they also propose a theory that he wanted to hire a tennis coach, but of course he already had a tennis coach. That he wanted to hire a tennis coach full time. Well, that was so that he could have the soft life, no doubt, of training 8 hours a day, 7 days a week, to play professional tennis on the international circuit. And so I cannot conceive that any of you would really believe that he would do that. Kill his parents so that he could buy a Jeep. Because there's really no evidence that he couldn't have asked his parents for a Jeep and they wouldn't have given it to him. I mean, they seem to be financially very generous with their children. No one testified that Erik wanted for anything. No one testified that he ever spent money on anything either. He didn't seem to be a high-priced kid. He wasn't running around in a fancy sports car. He wasn't running around with a lot of fancy clothes. In fact, the evidence is that after the parents were killed, he needed to buy a jacket. He didn't even own a jacket suitable to wear to the memorial service. So that brings us to the big ticket item, which is Lyle's purchase of the Rolex watches. And here's another place where I'd like you to be able to draw the line between Erik and Lyle. Don't get us wrong, I think it's very obvious that Erik Menendez adores his brother and idolizes him and feels very guilty that through his going to Lyle for help, they've both been in jail for 3.5 years and maybe in jail the rest of their lives. And I think he feels a great deal of guilt about that he expressed here, and he certainly expressed it in the tape recording that you heard, and he certainly expressed it to Dr. Vickery, and it's real. This was the idolized big brother. And I think something else that you may have seen, and I never know during a trial what you all actually see because there's a lot of different places for you to look. But when Lyle was testifying about his life, Erik was hysterical. At the counsel table, and it got real bad there at one point where we asked for a recess. When Erik was listening to Lyle talk about Lyle's suffering and Lyle's pain and Lyle's fear, Erik became completely hysterical. When Erik got on the witness stand and talked about his own, he didn't. And there seems to be a very special bond there where Erik cares in some way, I think, more for Lyle than he does for himself, which would, of course, be the family tradition. But my point is this, that there's no doubt also based on his testimony that Lyle adores Erik, but Lyle was raised to be in the image of Jose Menendez, and he was raised as the first son. And as a consequence, he did some things that he regrets. He molested his brother, and he is sorry about it, and I don't bring that up as a judgment against Lyle, but I bring it up as one of the many ways how, over the years, Erik suffered for being Lyle's little brother. Suffered at Lyle's own hands. And Lyle was something of a bully to him when they were younger, but that changed. And that changed around the time they were teenagers. Early, when Erik was about 13. And then his brother, in this incredibly cold, uncaring family, was the only person in his entire galaxy, if you will, not just world, not just universe, the entire galaxy, who showed any regard for Erik at all. Any protectiveness, any love, any caring, any concern. And I think that was the bond that can never, ever be broken in this family, the bond between the two brothers. But it hasn't always been easy for Erik to be Lyle's younger brother. For one thing, Erik Menendez at Princeton Day School is the second Menendez. And it isn't that people didn't like Lyle, it's just that along with a Menendez brother comes the Menendez parents. And Lyle, having been through that school once, I believe Erik testified, when he'd get into classes with the same teachers, there was like already a negative energy.
The judge is sitting there reading a book in the middle of... This is how much the judge respects the defense and doesn't even listen to her closing arguments. He's just sitting there flipping through some book. Anyways, I have to stop it here because if I don't, then you guys aren't going to have a video for today. So I got to get it cut and uploaded for you guys. So Thank you so, so much for watching. I appreciate you guys for being here. We will pick up right where we left off here, so don't worry, we're not going to miss anything. I will see you guys on Tuesday of next week. Take care. Bye now.